Would you like me to start by reading the call out?
Yes, please.
Sure. Hello, judges. I would like to begin by reading out a statement. This hearing is in the matter CA 009-2021 before the Chief Justice Tun Zaki Azmi, His Excellency Justice Ali Al Madhani, and Justice Wayne Martin, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The appellant is represented by Al-Tamimi & Co. Lead counsel is Rupert Reed QC. The respondent is represented by Clyde & Co. Lead counsel is Edward Knight.
Okay, thank you very much. So let's start with Mr. Rupert Reed. You want to formally introduce yourself and the parties and who are assisting you?
My Lord, yes. I appear with Mr. Tim Killen for the appellant, and as Mohammed said, Mr. Edward Knight appears for the claimant and respondent, whom I shall refer to as Globemed. My Lord, we're here on the appeal against the decision of Mr. Justice Field denying OIC permission to file a re-amended defence and counterclaim. In effect, to add a
basically, this still at the stage of interlocutory proceedings, hearings, isn't it? You have not even complete filed. You have not closed your pleadings yet. That's where this. Yes, Mr. Reed.
My Lord, no, there is no trial date that has yet been set. That was because Globemed, the claimant and respondent, was needed time in order to lodge security for cost. So we are at a relatively early stage. Clearly, the proceedings have been going on since essentially early 2018. There have been a number of interlocutory issues. Part of the problem with the judgment of Mr. Justice Field, as we will see, is that he seeks to attribute blame and culpability to OIC in respect of essentially the entire period of this action, and principally culpability in terms of the bringing of the application to the JJC. Just to finish what I was saying, the decision of Mr. Justice Field denied OIC permission to file a re-amended defence and counterclaim, which would add a complete defence to a claim for $36.5 million by the addition of a single point, a discrete point of UAE law, which is acknowledged by Mr. Justice Field to have real prospects of success. And in giving permission to appeal after a lengthy hearing by Mr. Justice Lord Glennie as a single justice of the Court of Appeal, gave permission on three bases, namely that arguably the judge had given insufficient weight to the importance of the amendments as a complete defence to a claim for $36.5 million. Secondly, that the judge had erred in his assessment of culpability. So the attribution of culpability was wrong. And thirdly, and possibly as a point of law, procedural law for this court, the judge had put too much weight on culpability over prejudice. Permission to amend should not be about rewarding good behaviour or punishing past bad behaviour. It should be about balancing of prejudice, looking forward and applying the overriding objective in managing the case going forward.
But Mr. Rupert, I was reading his judgment. He was very much against you on the illegality of the client, the respondent, or the legality. He was very much against you. He was saying, I don't agree with you.
He was very much against us on the JJC application. He was, in fact, a member of the relevant JJC, as I believe your lordship may have.
So am I.
But
honestly, I can't remember this case.
I'm grateful for that indication.
My lord, I don't think you were a member. I think you handed it down, but it was actually heard by or dealt with by a different panel.
Oh, I see. Okay.
And we believe that part of the problem in the judgment is that there is an element of prejudgment because the judge essentially borrows a key paragraph from the JJC's decision, which is excoriating in terms of an alleged intention to delay on the part of OIC. in circumstances where that decision was done on paper without any hearing and was supposed to be an allocation of jurisdiction, an allocation which in our submission was entirely necessary. So in our submission, the balancing exercise was entirely wrong and was skewed by an assertion of culpability. And I take the Chief Justice's point. We had a very strong feeling at the hearing that Mr. Justice Field was strongly against us. He felt strongly that the JJC application had been part of a strategy of delay. And unfortunately, that position, if you like, skewed the balancing exercise he was supposed to be undertaking by reference to considerations of case management, looking forward, by reference to the overriding objective, and turned it into essentially the suggestion that because of the culpable behavior procedurally of OIC as defendant, it would be unfair to allow an amendment which, as I say, if analysed purely in terms of the balancing exercise in our submission, that balancing would lead strongly towards granting permission for the amendment. It's necessary to look at some of the background documents. Your Lordships will be aware that there are two agreements in play. Both were signed in Beirut on the 13th of January 2015, indeed by the same individuals, albeit in different capacities.
Mr. Reid, I think if you could go forward, I mean, you can remind us of the subtle facts, but you don't have to go back to the history. You just go on your three grounds of appeal.
Well, I just wish to draw some points from these documents, okay, which I will then pick up by reference to my grounds of
yes, we'll hear you on that. Yes.
Okay.
Yes.
So, if I could start with the Memorandum of Understanding, that Your Lordships have at page 320 of the appeal bundle.
Mm. Okay. Yes.
So Your Lordships will see from the parties that essentially this is a JV, a joint venture between a UAE insurance company. Although it's called Oman Insurance, it's Oman in the old sense of Trucial Oman, i.e. the UAE as it was previously called. It's a very substantial UAE insurance company with a turnover of 3.59 billion dirham. And on the other hand, the other party being a Lebanese healthcare business and a related company owned by the chairman and CEO of Globemed, Mr. Karma. So that's Karma Holdings, Globemed, and Synergize, which is a subsidiary of OIC. Now you'll see from the recitals, particularly I want to draw Your Lordship's attention to the second recital, which recites the fact that Mr. L.L.C, a UAE national, owns 51% of the shares of GMGHS based on a side agreement signed by Globemed and Mr. L.L.C, and the waiver of shares document signed by Mr. Adel L.L.C in favour of Globemed, where Globemed effectively owns 91.05% of the shares. And then you see at Article 3 a provision for transfer of the shares. So Mr. L.L.C signs all needed documents and the shares are transferred to a structure set out in paragraph C of Article 3, so that the investment entity, that's GMGHS, owns 51%. So that is the correct approach in terms of the nationality requirement. So the investment entity, which will be a UAE company, owns 51% of the shares. But the reality at the time of the MOU is that Mr. Hello is holding shares subject to a side agreement, essentially making him a nominee, and subject to a waiver of shares under which he essentially waived profit and entitlement under those shares. Paragraph 4 at page 322, so Article 4 at page 322, we have a provision that the MOU will be essentially an interim joint venture or shareholders agreement as soon as the transfer has occurred and until a formal shareholders agreement has been agreed. And then if we move very quickly on to 330, we see that the MOU will have an effective date or effective period for 2 years from the date in which it is entered. And then over page at 331, Your Lordship see UAE law as the governing law and the exclusive jurisdiction of the DIFC courts. A welcome indication, I should add, that many businesses in the UAE see the DIFC courts as entirely capable and well positioned to decide issues of UAE law, a confidence that none of us, I fear, would want to dent. And then one sees a signature page on the 13th of January 2015, signatures on behalf of Globemed, Synergize, which is the subsidiary of OIC, and Karma Holdings. The other agreement, which is important for our purposes, is the Tpa Service Agreement. So the joint venture company, once formed, will provide health insurance administration services under the TPA. That is agreement is at page 277. And if we can go straight to 279, we see there the two parties to that. That's GMGHS, which is the joint venture company, and OIC, which is the company which will be essentially delegating its health insurance administration to the joint venture company. And you will see significantly from the recitals, in particular A, the client is an insurance company duly licensed to operate in the UAE, requires third-party administration services, and B, Globemed is a duly licensed third-party administrator. Just pausing there, one of the defenses in the action is that, in fact, GMGH was not licensed. It had a UAE insurance license, but it didn't have the requisite license from the Dubai Health Authority or indeed the Health Authority of Abu Dhabi. And those were critical licenses which it didn't have. That's just by way of background understanding. And then let's move on to 292. We see at clause 12, dealing with a term, that in fact the term was not specified in the document. That is because there were a number of further conditions precedent that were required to be fulfilled. For example, GMGHS was required to hold the necessary licenses. BUPA, which was the previous administrator, was required to approve the contract. And there were significant issues in terms of the runoff of business, the transition of resources, the transition of staff, the transfer of shares, and networking agreements with particular healthcare providers. All of that had to be resolved before the effective date could be filled in. And again, that is another important part of OIC's case going forward. GMGHS's claims under the TPA are essentially for wrongful termination. In itself, that's an extraordinary claim because OIC was to have been the majority shareholder of the joint venture company. But in fact, GMGHS is suing OIC for the entire profit. So Globemed is in effect seeking the entire profit that would have been earned by an entity in which OIC, my client, would have been the majority shareholder. OIC's defences under the TPA are, as I've suggested, that GMGHS was not licensed, and significantly too, that the loss of profits alleged, and your lordships will be aware that the tests in terms of causation and remoteness under UAE law are significantly different to those under common law. Common law applies a test of probability to loss of profit claims. Under UAE law, one is required to show that lost future profits were sufficiently certain, so the threshold, the bar is significantly higher, and that's as a result of Article 292 of the UAE Civil Code. So those are the two defences that are there on the pleadings, but an important and significant third defence is, if you like, the prior defence under the Memorandum of Understanding, and that's a defence under UAE law, and it's an important rule, we say, of public policy and public order, that any UAE company must have a majority UAE shareholder, and violation renders the company a nullity, and a third party can rely on that nullity in invalidating any agreements brought by that entity which is found to be a nullity. That, as I say, is a complete defence. There is no, for example, restitutionary claim that can pop up as in remedial form in order to remedy the absence of a contract or indeed a contracting entity. So that's the nullity case. Your lordships will have seen it pleaded. I can take you very briefly to that. It's at page 358 in the appeal bundle. And if your lordships have that, I could start at page 359. Your lordships will see it's the text in green, which is the re-amended claim, which is sought to be added. The nullity section begins at paragraph 2A, so it's a general averment that the claimant company is null and void. And then at paragraph 2B, in terms of the conflicts of interest, it's said that the law applicable to the validity of the corporate status of a company is the law of its place of incorporation, being the law of the UAE. And that follows, we say, because where you have a company, which is a registered entity, it follows that whether in deciding whether that company is properly registered and is a valid company, the starting point is ordinarily the law of the place of the jurisdiction of registration. And then in terms of UAE, as it happens, as a matter of governing law, that is also the governing law of the TPA and the MOU. So there's no conflict there. There would be a conflict in terms of jurisdiction because clearly part of our case in bringing the nullity case in the Dubai courts was that jurisdiction should be in the courts of the place of incorporation. Now, we appreciate that we have lost that point in the JJC, but in our submission, that is still highly relevant in this appeal, in our making the case that it was not culpable to bring our case, our nullity case, in the Dubai courts, because prima facie, as a matter of conflicts of law, it's the courts of the place of registration that would have jurisdiction. Now, of course, the JJC has found against us as a matter of conflicts of law in saying that, well, no, because there's a jurisdiction, exclusive jurisdiction clause, that trumps the ordinary conflicts of law provision. And we appreciate that. But as I say, that issue is still relevant in dismissing the suggestion that OIC behaved culpably in bringing proceedings in the Dubai courts. Still looking at the draft re-amended defence and counterclaim, paragraph 2C, we have essentially the nationality requirement set out by reference to Article 10.1, so 2C, subparagraph 2, reference to Article 10.1 of the Commercial Companies Law, the CCL 2015, setting out the ownership requirement that one or more of the UAE partners should hold at least 51% of the share capital. And it's important too, subparagraph 3, the explanation or the pleading that the UAE courts will look through nominee or trustee arrangements. I mean, that follows. There is no simple avoidance, if you like, of the nationality requirement by setting up nominee structures or trustee structures. And when one looks at that second recital of the MOU to which I took your lordships a moment ago, in our submission, the reference to the side agreement and the reference to the waiver agreement are precisely that. They are nominee arrangements. They are arrangements that are designed to deprive OIC of profits in the joint venture company. And so one would be left with a nationality requirement, left with the fact that Mr. L.L.C was simply a nominee who had waived his entitlement to profit. And so in those circumstances, we say both the ownership requirement and the profit requirement were violated. In circumstances, I should say, where the transfers never happened. So what we are left in a situation where Mr. L.L.C was holding the shares subject to the side agreement and the waiver agreement. Now, I accept that there may be some thought by your lordships that actually the nationality requirement has been relaxed in recent years, and indeed I think Justice Ali will tell me, but the Commercial Companies Law was amended, I think, in 2020 to allow foreign ownership in some commercial and industrial sectors, but banking and finance is excluded from that. And so the nationality requirement continues to apply in respect of all, pretty much most banking insurance, and specifically health insurance. So the position even if it were relevant, which it isn't, but the position has not, in fact, relaxed in respect of this type of business.
I hesitate to interrupt, but that's not correct, because this is an administration services provider, not an insurance provider, and it falls outside those. It is within the regulations permitting foreign ownership.
Well, we can have that
But
debate.
we can't have Mr. Reid making up submissions about the facts without notice and in these circumstances.
Well, we have a distinguished UAE lawyer on the bench. It is well known that banking and insurance, the administration of insurance in my submission is not a matter of commercial or industrial matter. It's clearly a matter related to insurance. I stand by my point.
Let's discuss that, Mr. Knight. When you come to your turn, then we'll consider those issues.
Well, if the issue had been brought up beforehand, I'd be able to do so in more detail.
Yeah.
But we now have it brought up within the appeal, and it's a matter of law which should have been raised before if it's going to be said now.
Never mind. We'll make our decision later.
But it doesn't matter. It doesn't matter.
It doesn't matter, my lord. It is purely an observation that if your lordships were minded to think that the nationality requirement was less important now as a matter of public order or public policy, in fact, the nationality requirement in our submission, clearly as a matter of law, it is only the amendments, as I understand it, have only come into effect in mid-2021. So legally speaking, irrelevant. It's not an issue which this court needs to decide. But in my submission, if your lordships have any feeling that nationality requirement or the foreign ownership rules are less significant, in our submission, they are just as significant, particularly in banking and insurance, and particularly in the health insurance business. If Mr. Knight wishes...
Mr. Reid, speaking for myself, I'll be deciding this appeal on the basis of the issues that are relevant, rather than on feelings about what the law might now be as compared to what it was.
Well, that's a very helpful indication.
Thank you.
So looking back at 2D, we have the effect of an infringement of the requirement being that the company is null and void. And 2F, we have the pleading that it's a point of public order. And then at paragraph 2G, we have the fact that under Article 16.2 of the CCL, a third party can request a nullity ruling, and that involves invokes the personal liability of a party purporting to contract for the company. And then in terms of UAE contract law at paragraph 2H, we have the fact that where a contract is contrary to public order, it is void. Reference to Article 210, that any party having an interest may raise the voidness of a contract. At paragraph 2I, we have reference to the Ministry of Justice commentary, which suggests that intuitively suggests that at least two parties are required for a contract, and that if a contract is found to be a nullity, then the contract shall be void. And then in paragraph 2J, reference to the nominee arrangements in the Memorandum of Understanding, paragraph 2J, subparagraph 2, the side agreement and the waiver of any right to profits. So that is dealt with expressly in paragraph 2J. So in our submission, we have, in this case, with Mr. Hello, classic nominee arrangements. We've seen the second recital. The 51% of shares were held on the basis of side agreement and a waiver agreement, and that in our submission, and indeed a draft re-amended case, offends both the ownership requirement and the profit requirement. And on that basis, we argue that the GHS is null and void as a matter of public order. Now, there are 4 points that I would like to make at this stage in passing. Firstly, that the defence in the draft re-amended pleading is a complete defence based on a short point arising out of 3 articles of the Commercial Companies Law, effectively Articles 10, 16 and 29. Secondly, it's a point entirely of law. It was argued before Mr. Justice Field in less than a day. GMGHL chose to take its legal points by way of its skeleton arguments. So it's a little rich of Mr. Knight to suggest that we are raising issues late. It's worth looking at how it's dealt with in that skeleton argument. That's at page 203 of the bundle. And if I could take your lordship straight to page 211 within the skeleton. And your lordship see at paragraph 29 in my learned friend skeleton at the bottom of page 211, no real prospect of success. And then essentially 2 points are taken. So paragraph 30, we see the reference to article 16.3 of the Commercial Companies Law. And that is set out in paragraph 31 below that. And your lordships will see that one of the issues in UA law is the apparent conflict between article 16.2, which suggests that the nullity of the company avails to the benefit of a third party, but at the same time, Article 3, which my learned friend relies on, dealing specifically with the liquidation of the company.
Mr. Reid, why does any of this matter? The judge below found that the argument that you wanted to raise by the amended pleading was arguable, and there's been no contention that the appeal should be allowed, should nevertheless be dismissed on the basis that that ruling was wrong. So there's been no challenge to that ruling. So why can't we just proceed on the basis that your defence is?
The point I would like to take, my lord, is that it's a really short point. It's essentially an argument of statutory construction dealing with Article 16.2 as against Article 16.3. And furthermore, we'll see at the bottom of page 213, I'll speed up, you see there the doctrine of the de facto company. That's a sharikat muhassa, which is a point of UAE company law, and essentially reference to Article 9 of the CCL. There is a limited amount of law in respect of de facto companies. These are companies by way of participation and sharikat muhassa. And there's a reference to a decision, a cassation decision, which you see an excerpt in paragraph 40, and then arguments in respect of certain provisions, articles 6, 7, 9, but essentially, and then at the bottom of page 215, we have finished dealing with delay. So it is a relatively short, this is 2 or 3 pages of my learned friend's skeleton, where he first raised these issues of 16.3 and sharikat muhassa. But in terms of the balancing exercise, we say not only is this a point on which the judge below found that our case was arguable, it's also a case which is susceptible to, which is a matter of legal argument and susceptible to being expressed by my learned friend in 2 or 3 pages of his skeleton argument, where he first raised the point. And indeed, there are no issues
at this stage, Mr. Reid. At this stage, I think you will just need to satisfy us that your likelihood of success at appeal, should we allow the amendment, is good or plausible, whatever the term used in the. As long as you can show that to us, that's all we need to. And as Justice Wayne rightly pointed out, the judge did mention something in his judgment about, you have some good points.
The judge went further than saying something. The judge found that we had real prospects of success. So in terms of merits,
can you show to me? Can you show to me where he said that?
My lord, I'm sorry. I'll come to judgment later. Just for your lordship's note, it's at page 232.
232. I'm sorry to interfere.
I can take your lordship quickly. No. But I was supposed to go through the judgment later. But for your lordship's note,
yes. Where did he say that? As I admitted that I was rushing through the judgment. I read through your submissions, but I was racing through the judgment.
Paragraph 57, page 250, the appeal bundle.
250.
Yes, I'll come to it later.
Yeah, I know, but I just want to.
If your lordship wants to note the point to come look at later.
I'm persuaded. Paragraph what did you say just now?
Paragraph 57, my lord, in the judgment, page 250 in the appeal bundle.
Okay, thank you.
The third point I would make in passing is that the nullity argument is alien to common lawyers. It's often said that the genius of the common law has been the limited liability company, and there are very rare cases where one can essentially sweep away the corporate veil or the limited liability company. And that, if you like, is because the company exists as a matter of registration, it exists as a matter of statute. Whereas in civil law, and in UAE law in particular, it is the principles of contract and partnership that underlie the existence of a company. And therefore, the nullity of a company is far less exceptional than it is in the common law tradition, where the circumstances for piercing the corporate veil or indeed looking through a company or indeed finding a company to be void are exceptional. For example, where there's fraudulent trading or wrongful trading or a company is being used as a facade. And fourthly, as Justice Wayne Martin has observed, there is a finding by Justice Field that there is real process of success, and significantly that finding in paragraph 57 at page 250 has not been challenged by Globemed. So there is no collateral attack or challenge on that finding. The scope of the appeal, as your lordships will have seen, is limited. There are a number of findings by Mr. Justice Field. There was an application to strike out an additional claim against Globemed. That strikeout application was granted. That has not been appealed. There was an application again by Globemed for immediate judgment against a claim to set off the additional claim. That too has not been appealed. It is only the decision on the application for permission to file the RADCC that has been appealed. Your lordships will have seen in the judgment of Mr. Justice Field that he analysed it as three applications. Firstly, an application to amend under RDC 18.2. Secondly, an implicit application, withdraw an implied concession under RDC 1552. And thirdly, an application to add a counterclaim. But in analysing those three applications, Mr. Justice Field found that there was no separate analysis required. What was required was the raising of the two questions, A and B, in paragraph 41 of the judgment. So A, was there reasonable process success? The answer, yes. And B, was this a suitable case for the exercise of the court's discretion? And that, of course, should have proceeded on the basis of a balance of prejudice and by reference to the overriding objective. It's also important in my submission to understand the procedural chronology. And I say that because, as your lordships will have seen, there is a strong suggestion of culpability on the part of OIC. And in our submission, your lordships need to understand what happened in terms of the procedural chronology in order to consider the allegations of culpability. The initial breach of the alleged breach of the TPA was on the 21st of May 2015. It wasn't until November 2017 that GHS, in fact, issued its claim. That's 2 years after the alleged breach. The claim is at page 266 for your lordship's note. The APOC, the amended particulars of claim, amended by consent of OIC, were issued on the 17th of May 2018. They are at page 268 for your lordship's note. And on the 3rd of January, right at the beginning of 2019, the Dubai OIC issued its Dubai court claim, seeking a declaration on the nullity issue. The Dubai court claim is at page 380 of the appeal bundle. And your lordships will see there the Dubai Court of First Instance, statement of claim, and then halfway down the page, subject declaration of nullity of the Claims Management Service Agreement. That's the TPA agreement. And then at the top of page 3 internally, so page 3H2 in the bundle, we have recital 2 from the Memorandum of Understanding. And then at paragraph 8, we have reference to the fact that the company is a null company, doesn't have legal capacity as a matter of public order. And then the court then has a request for a declaration of nullity for breach of public policy. And then at page 383, we have reference to Article 10 of the Commercial Companies Law 2015, and indeed reference to Article 16 of the Commercial Companies Law. Reference then to a court of the decision of the Dubai Court of Cassation. And then finally at page 385 for the prayer, if you like, the rule to establish the nullity of the TPA agreement. And then your lordships will see at the bottom a distinguished list of UAE lawyers who pleaded this claim. That's to say Assam Atamimi, Dr. Hassan Al-Arab and others, a very significant team of UAE lawyers who are prosecuting that claim in the Dubai courts. And this was the basis for the judge's finding that there had been a conscious decision not to plead the nullity issue. And in our submission, that is a fundamental mischaracterization of what OIC was doing. It was not consciously deciding not to plead the nullity action. It was consciously deciding to plead the nullity issue in the Dubai courts on its assessment as a matter of conflicts of laws, that the Dubai courts were the appropriate forum.
Mr. Reid, can you remind me, had you put on your defence in the DIFC court before you commenced proceedings in the Dubai court?
I believe so, my lord. Yes, I can.
And there's no. It said that you were aware of the nullity point, but chose not to raise it in the defence when it was first filed. Is that correct?
Well, it's right that it wasn't taken in the DIFC court because the decision was always to take it in the Dubai court, my lord. Yes, and my lord, I think
if you could help me at some stage, just the gap between the filing of the defence in the DIFC court when no point was taken and the commencement of the proceedings in the Dubai court. That would be helpful.
My lord, I can help you. It's 11 months.
11 months. Okay.
Yes. Lord,
well, that you were criticised for that delay. That is rightful criticism, isn't it, Mr. Reid? There's no answer.
I think in the skeleton we take that on the chin. I think we say that there is a delay of a year. That is just a question of the period of time taken by the team of UAE lawyers to put together to do that pleading. But we accept that. But what
There's no evidence of that whatsoever, Mr. Reid.
Well, leaving that to one side.
That is making up.
Well, Mr. Reid accepts that there was delay of 11 months, and we needn't go into why that was. But you say your point, Mr. Reid, is that once you commenced the proceedings in the Dubai court, as you say, you were entitled, you had reasonable grounds for doing so because that was the place of incorporation of the company. You say thereafter all your steps were reasonable, and I understand that. You say that Dubai court was a reasonable place to start. When you got and having started there, it was reasonable to refer the matter to the JJC. Once you got the decision of the JJC, there was an issue with respect to security, and so it was reasonable not to plead the amended case until the security issue had been resolved. That's your argument, isn't it?
My lord, yes. Security is the costs. There's no point in carrying the cost before the security is in place. We say the denial of security was unreasonable. The judge took the view that it was obvious that security was going to be granted. That was certainly not the position of Globemed. Even if it was agreed or ordered, the reality is that there are many parties who failed to provide security, even having agreed to do so or been ordered to do so. But I take the fact that your lordship is very familiar with the papers. I will try and take things more quickly. I do just want to say on this point of the conscious decision, that was by reference to a paragraph in the fourth statement of Mr. Kishore. I just wanted to take your lordship briefly to that. That's at page 109 in the appeal bundle. And paragraph 32 is the offending paragraph from the perspective of Mr. Justice Field. So picking up 5 lines into paragraph 32, the nullification claim is a claim under UAE law against a UAE company outside the DIFC. And OIC took the view that the Dubai courts were the correct forum in which to bring that action. That's why the nullification claim was raised, but not developed in the original defence. Following the JJC decision, OIC therefore had no alternative but to bring the same cause of action in the DIFC courts, which it's doing.
Can you help me with that, Mr. Reid? What does that mean? That's why the nullification claim was raised but not developed. Was it raised in the original defence?
No, my lord, no. I think
That's right.
My lord, it wasn't pleaded precisely because it was always the intention to raise it in the Dubai courts.
Right. Okay. Thank you.
But that paragraph is the basis of the judge saying that there was a conscious decision not to plead the nullity issue. And as I say, in our submission, that analysis is simply wrong. As your lordship has suggested, it's then suggested that the application to the JJC was in some way abusive or was in some way part of a strategy to delay, and the culpability is said to be attached to that. Now, we say in our submission that Dubai court proceedings were entirely justifiable. We've made the point as to forum that we, in our submission, reasonably took the view that the appropriate forum was the courts of the place of registration, and indeed. One can see the very real risk of inconsistent judgments that arises otherwise. If, for example, courts in one jurisdiction consider a company to be a nullity, but the company remains registered in the jurisdiction of registration, there is an obvious risk of inconsistent judgments, an obvious risk of confusion, and one can see why, as a matter of conflicts of law, that default provision or that provision, that rule, if you like, or principle exists. Secondly, as an issue of UAE law, to the extent that this was a matter of UAE law, and indeed once we've seen Globemed's own case in respect of Article 16 of the Commercial Companies Law, its own case in respect of the Sharikat Muhassa, the de facto company, again, there is an obvious argument for these issues being determined by UAE judges in the UAE, in the onshore Dubai courts. Not least because, for example, in respect to Sharikat Muhassa, one is relying on, for example, Egyptian authorities, the wasit, the commentary on the Egyptian civil code, which informs much of the analysis of the UAE civil code. In terms of the JJC application, GM, the case that was advanced in the JJC by Globemed, always accepted that there was, or indeed made the case that there was no conflict between, on the one hand, pursuing the contractual claims in the DIFC court and the corporate claims in the Dubai courts. I'm not going to take you through all of the submissions, but I think it is worth looking at Globemed's case in respect of this, and it's possibly worth picking up at page 428 in the appeal bundle.
What page again, please, Mr. Reid?
428. 428.
428.
Does your lordship have it?
Yes.
So at paragraph 41, this is the submission on behalf of Globemed. It's submitted that if and insofar as the tribunal considers that such matters as to the incorporation of the respondent are matters which fall within the exclusive jurisdiction of the Dubai court, that issue is separate and distinct from any dispute arising with respect to the enforceability and or validity and or formation of the agreement, which falls within the exclusive jurisdiction of the DIFC courts pursuant to clause 18.3 of the agreement. It would be possible and indeed correct as a matter of law for the distinct issues to be dealt with separately by the respective courts with jurisdiction. In circumstances where the tribunal considers that, one, the Dubai court has exclusive jurisdiction to determine the issue of whether the respondent was validly incorporated, and the DIFC courts have exclusive jurisdiction to determine whether the agreement is valid and binding, whether by reference to the effect of the invalidity of the company or otherwise, no conflict of jurisdiction arises pursuant to Decree 4 of 2016. So their argument is there's no conflict of jurisdiction Because on the one hand, there's a corporate issue as to the validity of the company. That issue can be determined by the Dubai onshore court. And there is also the contractual issue, which can be determined under the exclusive jurisdiction provision in the contract, in the DIFC courts. And then one sees, in terms of the relief sought at the bottom of page 429, for all the above, the respondent requests the Honourable Tribunal to, and then if one looks at B, this is the primary relief sought, order that all claims, disputes and differences or other matters arriving out of or in connection with this agreement be heard before the DIFC courts and the proceedings before the Dubai courts be ceased. Or, so this is the alternative case, in the alternative, order that little one, all claims, disputes, differences or other matters arising out or in connection with the agreement be heard before the DIFC courts, and little Roman 2, any determination as to the response incorporation be heard before the Dubai courts, if such relief is subsequently sought by the applicant. So it was implicitly accepted as part of the Globemed's alternative case that actually there was no conflict of jurisdiction, precisely because the Dubai courts would have jurisdiction over the corporate issues, but not the contractual issues. The JJC's decision is at page 431. That was reached on the 20th of June 2019. Well, I should just add at this point, the decision, for reasons we don't understand, was not communicated to the parties until September. So there's a delay of 3 months, for which OIC cannot sensibly be responsible in terms of delay. The legal decision of the JJC was by reference to the opt-in jurisdiction. That's at page 435. And one sees at paragraph 8 of the JJC decision the reference to the jurisdiction clause in Article 18.3 of the agreement. So that trumps any principle of conflicts of law by reference to the express agreement of the parties, party autonomy, if you like. But then it's the obiter comments that follow that are in our submission problematic, and one finds those at paragraph 9. So the final sentence of paragraph 9, the appellant's attempt at inventively interpreting the provisions of the procedure code in establishing jurisdiction of the Dubai court amounts to no more than procedural tactics and only seek a conflict of jurisdiction. So that's an allegation of base motive against OIC, that all it was seeking to do was essentially create an artificial conflict of jurisdiction. And then paragraph 11, accordingly, it's to a contrived extent, there is a dispute of jurisdiction, which gives the tribunal jurisdiction. But the tribunal regards this as an artificial dispute created by the appellant solely for the purpose of avoiding or at least delaying resolution of the merits of the claim. And in our submission, there is simply no basis for that unwarranted suggestion that this is purely a matter of strategy in terms of making the application to the JJC. And one finds in the judgment of Mr. Justice Field below, he sets out paragraph 11 in full, paragraph 28 of his judgment. And in our submission, there's a strong suggestion that the judge had prejudged that issue of culpability by reference to this comment, obiter comment of the JJC. And as your lordship rightly suggested, thereafter there is an issue in respect of security for costs. OIC applied for security in October 2019. For your lordship's note, that is at page 1273, 1273 in bundle B, which is a bundle below. I don't think I need to take you to the application itself. As your lordship suggested in our submission, it's unsurprising that OIC delayed its amendments. And remember, these weren't just amendments in respect of the nullity issue. There was also the additional claim in respect of the failure to transfer the shares, which is what gives Globemed its ability to claim the entire projected profits of the joint venture and not just its minority share. So there was a substantial degree of cost in repleading and in pleading an additional claim that were involved. It was Globemed in our submission that delayed. There had been an initial suggestion of security for costs in January of 2019, and that is at page 445 in the appeal bundle. That was refused outright on the basis that the application for security was made late. Much later on, in December of 2019, an offer was made of a parent company guarantee from Lebanon. Now, clearly, and indeed that was a guarantee that would be provided by the parent company to GMGHS, so not to OIC. And again, for your Lordship's note, I don't think we need to look at it, but in bundle B at page 2299, we have the rejection of that offer. If your Lordships want to look, I'm very happy to do that. So that's bundle B 2299. So this is a letter of response of the 12th of December from Al-Tamimi. So starting, we refer to the defendant's application regarding security and to your client's proposal set out in your email of the 25th of November 2019. And then over page, at page 2300, the second paragraph, we do not consider that the form of security proposed by your client would be readily susceptible to enforcement or simple and straightforward to execute against. In particular, we note that A, the proposed promissory note from Globemed would provide our client only with an unsecured contractual right to sue GML and offers no enhanced form of security, such as, for example, charge over property or right to call on funds in an account. In this regard, it's unknown whether GML has any assets within the jurisdiction, either the DFC or onshore UAE, which could be enforced against. And C, further, the structure proposed includes a guarantee offered by the shareholders to GML in order to back GML's proposed promissory note to our client. That's plainly unsatisfactory. And then D, finally, engaging in any sensible analysis of your client's offer would require a thorough understanding of the financial position of GML and its shareholders. So again, it's not a security backed by assets, it's a security backed by a contractual promise on the part of the shareholders of GML in Lebanon. So there was no security in the UAE. And it was only on the 21st of January 2020, some months after the initial application, and indeed a year after the initial request for security, that Globemed agreed to provide a UAE bank guarantee, and indeed to pay the costs of Globemed's application, OIC's application for security for costs, which is, in our submission, an admission on the part of Globemed that it had been wrong to reject the application for security. And we have that at page 2373 in this bundle B. So page 2373, this is the 21st of January, an email from Clyde & Co. to my solicitors. Top of page 2373. Further to your email below, the claimant agrees to pay the defendant's costs of the security application to be assessed if not agreed. Given the parties' agreement on costs, the directions sought in the draft CMO proposed by the defendant are now agreed. And then if one goes down a page to 2374, this is the confirmation by Clyde & Co. of the same date, the 21st of January 2020. And then the third paragraph of that email at the top of the page, the claimant confirms that the orders sought in the defendant's draft CMO have been agreed by the claimant. So that was the agreement to provide effective security for costs. And one has at page 2375 below the order which was being agreed. And then one sees at the bottom of page 2375 the order that the claimant shall provide security costs to the defendant in the amount of $653,000 by way of a guarantee from a UAE-based bank. And that security is provided within 28 days, but no later than the 15th of March 2020. So there's a hiatus at that point between January and March for the provision of this bank guarantee. So it's going to take Globemed some 2 months to set up the bank guarantee in the UAE. And one sees then provision in paragraph 2 for a provision date, so whenever they finally are able to provide it. And then all of the directions that follow in paragraph 6 and following of this case management order are by reference to the provision date. So whenever security is finally provided. So for example, witness statements are to be 35 days after the provision date, whenever that may be, subject to this long stop of March, 15th of March, mid-March. So, and it may be that actually the action should have been stayed, and it may be that OIC should have formally applied for a stay of the action pending the provision. And indeed, that's, as a matter of English procedural law, relatively unexceptional, that the court, where there is security for costs being sought, will stay the action because of the obvious procedural unfairness of a party incurring costs before security has put in place. But if the fault is therefore of OIC in not making that application, in our submission to punish OIC for not making an application, which in our submission would probably have been granted, is unfair as a matter of the balancing exercise. In parallel to the application for security for costs, OIC was entirely open as to its intention to file the RADC, the Recommended Defence and Counterclaim. Its intention was made clear as early as October 2019, and if one goes to the appeal bundle, back to the appeal bundle at page 447, one has a letter. This is the letter of the 30th of October. And then at the bottom, towards the bottom of page 448, one sees there the proposed draft re-amended defence and counterclaim. Now, I mean, clearly, there's nothing exceptional. Essentially, the JJC has found that the Dubai courts must cease to entertain the nullity issue. And it's implicit in that that is a matter for the DIFC courts to hear. So the matter must therefore be properly pleaded before the DIFC courts. What this letter is communicating is that there will be a re-amended defence and counterclaim so that the nullity issue, which has been ceased to be entertained by the Dubai courts, can be properly considered and determined by the DIFC courts. And that is, as I say, clearly intimated and communicated at section C of this letter of the 30th of October. The draft RADC are not, in fact, served until January 2020. As I said, that relates to the issue of security for costs. There was, in our submission, absolutely no surprise involved. And if I could go back to Bundle B, and if I could take you briefly to page 2284. This is an email from Clyde & Co. And at the top of page 228, and I should say the date of this is November 2019. And at the top of page 2284, we see Clyde & Co. saying as follows: the defendant has not provided the claimant with a copy of the proposed amended pleading, despite the defendant first raising its intention to seek the claimant's counsel consent over 2 weeks ago. Given the proceedings filed before the Dubai court, it is reasonable to assume, in the absence of a draft amended pleading, that the amendments proposed will address the same issues raised before the Dubai court. In such circumstances, we note that the defendant has conveniently failed to provide any explanation as to why those arguments filed before the Dubai court require further consideration in order for the amended defence to be prepared. So essentially they're saying we'll get on with serving the re-amended defence and counterclaim, because obviously it's going to be the points that were taken before the Dubai court. So as we would say, absolutely no surprise. Going back to the appeal bundle.
So Mr. Reid, you say 2284. What's that page number in? That's in the.
That's in the B bundle, my lord.
The B bundle.
2284.
Thank you.
Does your lordship have that?
Yes, I do. I'm
grateful. And then going back into the appeal bundle, we have the page 455. The registry, there was a CMC that was in the diary. The registry required that the defendant should, by the 30th of January 2020, if they wish to, file an application to amend the defence and counterclaim. So that was the registry saying, essentially setting a deadline. The OIC complied with that deadline, and the re-amended defence and counterclaim was then served. So that's where we are in terms of the service of the re-amended defence and counterclaim. In terms of explaining how we get to where we are now, the application was heard in June 2020, June of last year. It was only in October of 2020, some 4 months later, that the application was refused. And it was only in March of this year that the application for permission to appeal was then refused by the judge below. So there has been a significant delay in terms of the appeal and the permission to appeal application being heard by the judge below. But again, in our submission, that is not something for which OIC could possibly or sensibly be held responsible. Your Lordships will have seen the judgment of Justice Lord Glennie, in which he found that the appeal has reasonable prospects of success. I'm bound to say that he said he was only just persuaded, but he was persuaded and he found real prospects of success, even without considering whether there were other compelling reasons. And in our submission, there were other compelling reasons for granting permission, not least the issue of public policy and public order that were raised by the nationality requirement. And he did so also without any reference to the recent decision in fixed sense management, which your Lordships have at page 522. I don't think I need to take your Lordships to it, but essentially in that case, the Chief Justice found that where an order struck out a claim or defence in such a way as to give finality, the court should be sympathetic and readier to grant permission to appeal. So that we say is an important decision of the DIFC Court of Appeal, to which the judge was taken, Justice Lord Glennie was taken, but which he did not feel he needed to refer to because he found that there was a real process of success, even without reference to that decision of the DIFC Court of Appeal. In terms of the legal test for an appeal, that is set out in RDC 44117. Essentially, we have to show that the decision of Mr. Justice Field was wrong. Obviously, there's no suggestion of procedural or other irregularities. So it's purely on the first ground, if you like, under 44117.1. There is reference in the note. I don't know if your Lordships have the DIFC court practice, but in 44117.2, note 44117.2, there is reference to the IGPL decision.
So what's that page number again, Mr. Reid?
Page number is 596, my Lord. I didn't.
Thank you.
From your book, Mr. Reid? From
Yes,
your
Lord.
book? Oh, this one.
No, your Lordship's now provoking me. I'm pleased to say the publishers are keen to publish a second edition, so it's
Good.
So page 596, note 44117.2, in IGPL and Standard Chartered Bank, the Court of Appeal rejected submissions based on English authorities that wrong in RDC 44117 was restricted only to an error of law, and 2, the focus of the test was whether the conclusion of the court below was plainly wrong. The Chief Justice confirmed that the relevant test for an appeal was whether the court was wrong, and errors for these purposes could be errors of fact as well as errors of law. So we would say that the Court of Appeal was making clear that 44117 should not be glossed, and the attempt in that case was made to gloss it by reference to English cases that suggested that wrong could only refer to errors of law, couldn't be errors of fact, and also that wrong meant plainly wrong. And again, the Court of Appeal rejected that attempt to gloss 44117. This is an appeal against a discretion. We clearly accept that is inevitably difficult, but it is an exercise of discretion that is based on an evaluative assessment. And there is often a suggestion that evaluative assessments are more capable of being wrong than an exercise of a discretion, because an exercise of discretion involves a certain a step beyond, if you like, the evaluative assessment. We say that the judge misdirected himself, and I should say that the test in terms of the appeal on an appeal of an evaluative assessment, the multifactorial evaluative assessment, is whether the judge misdirected himself, whether he left relevant factors out of account, whether he took irrelevant factors into account, and whether he took a decision outside the range of reasonable conclusions that are reasonably available. In the old language, the decision that is capable of reasonable debate. Your Lordship has in the bundle, page 627, the Jopling and Leavesley decision, which essentially is Lord Justice Lewison setting out those tests in terms of misdirection, relevant factors, irrelevant factors, and outside the scope of conclusions reasonably available. I think Justice Wayne Martin in the IDBI Bank and Amira Foods case suggested that those principles were well established. Yes, that case is in the bundle. That's at page 697 of the appeal bundle. And that's a decision of Justice Wayne Martin, and the relevant paragraph is 104 within that, which is at page 708. So reading from paragraph 104, Amira also draws attention to the characteristics of an assessment of the kind impugned, which necessarily involve elements of discretion and evaluation, sometimes described as multifactorial assessments. Amira submits correctly that it's well established that appellate courts are slow to interfere with decisions of this character, and will only do so if it's apparent that the judge has made a mistake of law or applied the wrong principle, or the conclusion is so far outside the range of conclusions reasonably open as to sustain the inference of error. These principles have been accepted in this court and will be applied in relation to this ground of the appeal. Rather unfortunately, that we don't have footnote 47. But again, in the Dubai Court practice at page 154, we do have at page 154 in the blue book, we do have reference to the English authorities and then to the two DIFC Court of Appeal decisions, that's to say Protivity in 2016 and Al-Kharafi and Bank Saracen Alpen of 2019, where the court confirmed the principles that apply in respect of an appeal, the appeal of an evaluative decision. So those principles are now firmly accepted as a matter of DIFC law. And in terms of grounds, as your lordships will have seen, our grounds are three. Firstly, a failure to properly affect the balance of prejudice. We say that's both a misdirection and also a decision that is wrong in being outside the range of conclusions reasonably open to the judge below. Secondly, there's a failure to distinguish a proper approach on late and very late applications. And this is an important point of law. Is in our submission, it is only where an application is made very late, and that is expressly defined by the relevant English judge as being in trial. It is only then that issues of culpability arise, because the applicant is required to explain the delay in bringing that very late application. And thirdly, there's a failure to accord proper weight to the reasons for delay. And that essentially it means that the culpability analysis in our submission has gone wrong, in that matters are taken into account which ought not to have been taken into account. And I should say that it's not.
So, Mr. Reid, where are you reading from? Because I've got the grounds of appeal dated 22 March 2021 that don't appear to correspond to that. There's another set, is there?
Sorry.
Yeah,
so I've got the set.
My lord, there isn't another copy, and I was going to draw your attention to that very fact. That these are not the grounds that Mr. Reid is now enunciating are not the grounds in the grounds of appeal, and he is expressly in his skeleton argument disavowed, saying that the judge's decision was so unreasonable that no reasonable judge could have made it. He relies on misdirection and the absence of consideration of factors.
Well, my lord, the grounds are set out, as your lordship says in paragraph, page 4 of the appeal bundle.
Yeah.
So in refusing the application, the learned judge failed to consider the relevant prejudice to the parties. So that's the relative prejudice is clearly a matter of the balancing exercise. So we say the balancing is wrong. And then at 1.2, so there was no trial date listed. So we say not a very late application. And the learned judge failed to properly distinguish between late and a very late application. I'm reading from the grounds.
Yes.
And thirdly, at 1.3, the judge failed to accord proper weight in consideration of the events relied on in the judgment as constituting delay.
Yes, all right.
So,
I understand. I understand now. Thank you.
I may have been characterizing, but I don't think I've strayed from those three grounds. And your lordship will have seen the analysis of Lord Glennie, which to some is consistent with that. So he found that there was insufficient weight on the balancing exercise to the importance. So essentially, he was picking up the first ground. Secondly, Lord Glennie found that there was an erroneous assessment of culpability, and we say that is essentially the third ground. And
Where is
thirdly,
that? Sorry, Mr. Reid, where is that in the e-bundle? Where is Lord Glennie's decision?
Lord Glennie is at page 490, my lord.
Thank you.
And specifically page 493, paragraph 6. So applying the test set out in 4419, I'm persuaded, only just persuaded, first, that it's arguable that the judge gave insufficient weight to the importance of amendments. So that's the first ground. In other words, the case sought to be advanced would, if successful, provide a complete defense to a claim for $36 million odd. Sorry. Second, that it's arguable that the judge erred in his assessment of culpability for some parts, at least, of the delay in raising the issue in these proceedings. And third, it's arguable that the judge placed too much weight on the question of culpability for delay as he sees it, as opposed to the question of what prejudice, if any, would be suffered if the amendment was allowed. And we say, essentially, that is the second ground, because it is only where one is dealing with a very late application that culpability should come into play. And if culpability doesn't come into play, then one is left dealing with issues of, strictly dealing with issues of prejudice. And it's that third point taken by Lord Glennie, and indeed our second ground of appeal, that raises in our submission an important point of procedural law. Permission to amend should not be punishment for perceived or alleged bad behavior. It should be, unless one is in the territory of a very late application, where one's at trial, there is a complete mess in that a party is seeking to redraw its case at trial in circumstances where there may be disclosure issues, there may be issues as to whether certain witnesses have given relevant evidence. And in those circumstances, it is appropriate in our submission to assess the culpability of, well, why is this application being brought so late? But in circumstances where one's not dealing with a very late application, it ought to be a matter of case management, a matter of looking at the overriding objective and deciding whether going forward the prejudice in allowing it outweighs the prejudice to the other party in not allowing, or to the applicant in not allowing the amendment. In terms of the judge's reasons, we can look at those. They're at page 244. Um, 244. So paragraph 41A, we have the finding of a real prospect of success. Sorry, this is the setting out the test, so that he needs to be satisfied that there's a real prospect of success, as he does, of course, find. And then B, this is a suitable case for the court's discretion to be exercised in favour of an application, having regard inter alia to 1, the impact of granting the application on GMGHS and the impact on OIC if the application be refused. That is essentially the correct balancing exercise. The problem in our submission is that the judge fails to apply that test. He rehearses it, but does not effect it. Continuing, little 2, the delay in bringing forward the new case. 3, the explanation, if any. And pausing there, delay and explanation are precise, ought to be matters of the balance of prejudice. So in terms of assessing the delay, is there going to be significant prejudice to the respondent in allowing this going forward in terms of the management of the proceedings? It ought to be a matter of balance of prejudice, but the judge applied the analysis of delay and explanation as an analysis of culpability or alleged culpability, which in our submission ought to be relevant only on very late applications. And lastly, the judge refers to the overriding objective, which of course is dealing with the case justly. And at 3, he sets out the test in terms of what is proportionate. So little a, the amount of money involved. Well, clearly there's a vast amount of money involved here, which ought to weigh in favor of permission being granted. The importance of the case, well, again, where one's dealing with significant sums and a nullity issue as a matter of public order and public policy, that also underlines the importance of the case and therefore should militate in terms of permission being granted. Complexity of the issue, and D, the financial position of each party. Well, there's no suggestion that either party was financially, would be financially prejudiced in terms of its ability to deal with the proposed re-amended case. And then finally, ensuring that it's dealt with expeditiously and fairly. Well, as I say, we say that should be in terms of going forward. At paragraphs 42 to 57, the judge then considers the relevant UAE law on which he finds there's a reasonable real prospect of success. We don't need to look in detail at that, but it is worth pointing out that the judge managed to deal with it in this judgment, albeit at an interim stage on a threshold level. But it was dealt with within 15 paragraphs of his judgment below, looking at the relevant statutory provisions. Roughly the same number of paragraphs, indeed, that Mr. Knight dealt with it in Globemed's skeleton. And indeed, he deals with it as an issue of the statutory construction of Article 16 of the CCL and the issue of the de facto company, the Sharikat Muhassan. So that's where he deals with the finding that there is a real prospect of success in the amended case. The exercise of discretion starts at paragraph 58 of the judgment. So I turn to consider whether the court should exercise its discretion. And then he sets out the various parties' arguments. And at paragraph 64, he picks up in terms of his findings. So in my judgment, the proposed deletion of the last sentence of paragraph 2 of the amended defence amounts to withdrawal of implied admission. So he deals with the fact that there's an implicit application of permission. But importantly, at the last sentence of paragraph 65, however, in a case such as that now before the court, the application will be primarily decided on the basis that it's an application to amend to plead a new defensive claim case, which will be subject to the requirements articulated in A and B below. So there are no separate considerations required in terms of either the application for permission to bring a counterclaim or indeed the implicit application to withdraw an admission, an implicit admission. And then at paragraph 66, well, I should say paragraph 66, he explains why he says the discretion should be exercised against the granting of OIC's application. My reasons are these. OIC had 3 years after it renounced the TPA agreement to consider what defences it might have to claim by GHS for breach of the agreement. And it's plain from the evidence contained in paragraph 32 of Mr. Kishore's fourth statement that OIC took a conscious decision not to plead the nullity point when it served its defence on the 15th of January. Well, we've looked at that paragraph of Mr. Kishore's statement. And we've explored why that is, in our submission, a mischaracterization of what is said by Mr. Kishore. Second, OIC then let almost a whole year go by before seeking to have the nullity point decided in the Dubai courts. Well, as I say, we accept that, but in our submission, that is a matter of historical delay, which ought not to have affected or infected the analysis going forward of the balance of prejudice that was required by reference to the overriding objective, which led to GMGHS's claim being stayed for almost a further 10 months down to the publication of the JJC's decision. Well, the delay there follows, unfortunately, inevitably from the making of an application to the JJC. So that delay, if you like, hangs on the decision to apply to the JJC, and therefore, to the extent that we say that application was reasonable, the delay that followed cannot be attributed as a matter of culpability to OIC. We say that application was made reasonably, insofar as there was further delay by reason of the delay of the JJC in communicating its decision until September 2019. That again is not the time for which OIC can be considered to be responsible. And then, as a direct consequence of the delay resulting from OIC's Dubai proceedings, the second trial date fixed for the 22nd of September was lost. Pausing there, although it's said to be the second trial date, in fact, when the matter was first issued, a very rapid trial date was set almost automatically, but that was never a trial date that was, in our submission, taken a serious trial date. It is accepted that when the JJC application was made, that inevitably meant the vacation of a trial date, but in real terms, that was the first trial date that was lost. And as already recorded, the JJC concluded that OIC had created a jurisdiction dispute solely for the purpose of avoiding or at least delaying the resolution of GMGHS's claims. Well, that is simply raising the obiter comments in the JJC decision that there is a strategy of deliberate delay, which we OIC categorically rejects. And over page, it follows, in my opinion, that it would be contrary to fairness and justice for this court to condone OIC's conduct in launching the Dubai claim. So, a culpability is alleged essentially both in bringing the Dubai claim and in bringing the JJC claim. Both are said to be part of a strategy, or considered to be part of a strategy of delay. And then 67, further in an alternative, even if OIC's main purpose in bringing the Dubai proceedings was not to avoid or delay the resolution of GMGH's claim, so accepting that that may not be the case, the unexplained omission of OIC to plead the nullity point in its defence. Well, as I say, in our submission, it's quite clear why it was not pleaded in defence. It was because it was to be pleaded in the Dubai proceedings. OIC's delay in waiting for almost a year before issuing the Dubai proceedings, which is accepted, and the issuance of those proceedings, which was bound to lead to a stay to GMGHS's claim. So again, reference to the alleged culpability of the JJC application, all constitute conduct that renders it unfair for OIC now to be permitted to plead its nullity claim. So there's a logical jump, we would say, between, on the one hand, say, alleging culpability in relation to the JJC claim, and therefore saying by reason of that culpability, it would therefore be unfair to Globemed to allow the amendment to the pleading. And then paragraph 68, in addition, other matters that count in favour of refusing OIC's application. In my judgment, the prolongation of these proceedings beyond the 22nd of September 2019 might well have resulted in court time not being available to other litigants. Well, the application to the JJC was made in early 2019, and that which meant that the vacation was several months before the 22nd of September. So it's unclear how there could be a significant risk of prejudice to other litigants. And then paragraph 69, OIC culpably delayed in issuing this application after it had noticed the JJC's decision the 23rd of September. So that's a delay of 4 months in circumstances where the security for costs application was being pursued before the relevant costs were incurred. So what one sees is a layered analysis of culpability, but essentially returning again and again to the fact of the Dubai court proceedings, albeit characterized as a conscious decision not to plead the nullity issue, and a constant return to the JJC proceedings and the delay that resulted from that, and the vacation of the trial date that resulted from the JJC proceedings. In circumstances where there was clearly a conflict of jurisdiction, and the issue of that conflict had to be resolved, we say, by the JJC. Then 67, there's a 69 reference to further reference to culpable delay, and then paragraph 70. It follows that for the reasons I've given in paragraphs 59 to 69 above, OIC's application for permission to re-amend the amended defence and to plead a counterclaim based on the nullity claim is refused. So that's how the application is refused. As your Lordship has seen, we rely on 3 grounds. The first is the failure to effect the balance of prejudice. Now, when one effects a balancing exercise, one necessarily needs to look at both sides of the scales. And the starting point in our submission is to look at what would happen if permission was granted. And in our submission, if permission were granted, there would be minimal inconvenience or prejudice to GHS. We are, of course, dealing with procedural prejudice, not strategic prejudice. Clearly, there is prejudice to GHS in the amendment being allowed, but it should be considered as a matter of procedural prejudice. All that would be required if the amendment were allowed is an additional day of trial time. We've seen in the judgment it's dealt with in 15 paragraphs. In Mr. Knight's skeleton argument, it's dealt with in 16 paragraphs. It is a discrete point of UAE statutory construction in terms of Article 16C of the CCL, and also the argument of the de facto company, the Sharikat Mahassin. The legal argument, as I say, is largely a matter of statutory construction. This court is well versed in terms of considering UAE law. It can do so under the international approach in Fidel and Felicia. And I don't think I need to give you references for that case. It's dealt with in note 31.12.2 in the Dubai DFC court practice, the Blue Book. But essentially, this court is comfortable dealing with issues of UAE law, not least where one's dealing with the civil code, the CPC, or the commercial companies law. These are statutes with which the DFC court is well familiar. They are statutes that are well translated into English. The DFC court has UAE judges who are obviously expert and experienced in these sorts of issues. The trial date has still not been set. That, as I understand, results from the hiatus arising from GHS's delay in agreeing effective security for costs. The only prejudice would be an extra day of trial. And indeed, if there were a UAE judge at trial, one would anticipate that it could be even less than a day, because a UAE judge would no doubt have a pretty ready understanding of Article 16 of the CCL and indeed of the de facto company issue. There would be no significant disclosure that would be required. We can see from the face of the Memorandum of Understanding that there was a nominee agreement and there was indeed a waiver agreement. It is a matter of the legal consequences in terms of nullity of those side agreements. Then looking at the other side of the scales, in terms of the prejudice to OIC if there's a refusal to grant permission, so a prejudice to my client, the judge found, of course, that the defence had a real prospect of success. That has not been challenged by Globemed. In crude economic terms, even if a defence had only a 50% chance of success, if it's a complete defence to a $36 million claim, in crude economic terms, the value of that defence is $18 million. We all know as practicing lawyers that if this defence is on the pleadings, it will have a significant impact in terms of the dynamics of any settlement or settlement proposals. It is clearly a matter of significance in terms of the case going forward, which is why Globemed is so keen to keep this nullity point off the pleadings and out of the trial. In our submission, Globemed have been opportunistic in their approach. They seek the entire profit of the joint venture. In circumstances where the JJC has ordered the Dubai court to cease entertaining, implicitly on the assumption that the DIFC court has jurisdiction and will therefore be able to entertain the issue. Globemed is essentially seeking a double coup, a double whammy, because not only are they seeking all of the profits of the joint venture, but they're also essentially seeking to have the nullity issue removed from both courts. So they've had it removed from the Dubai courts, and now they wish to ensure that it is not pleaded and not heard by the DIFC court. All of that is claimed in the name of fairness to GMGS. But in our submission, there will be significant unfairness and injustice to OIC if it cannot make its nullity defense at trial. GM's response on the first ground has been that the balance of prejudice was a fundamental basis of the judge's decision. Now, I accept that the balance of prejudice is rehearsed by the judge, but there is no attempt made to assess the weight or the prejudice, indeed on either side of the scales. There's no analysis of the consequence for each of the relevant parties of permitting the amendment or indeed refusing the amendment. What appears to be central or fundamental to the judge's analysis is rather the assumption that the Dubai court proceedings and the JJC application and the delay resulting from that was in some way culpable, and that it would be unfair by reason of that culpability to permit the amendment. We don't understand the logical connection between the alleged culpability and the alleged unfairness to Globemed. And in those circumstances, we say it is clear that the judge has failed to carry out a reasonable balancing exercise. Secondly, Globemed says that OIC is seeking to go behind the judge's findings. So there's a suggestion made that these are findings of fact, that there was culpable delay, that there was abuse of process, or the balance of prejudice. All of those are clearly evaluative assessments, multifactorial evaluative assessments of fact and law. And the evaluation requires the weighing of a number of factors, which is susceptible in our submission to the right answer, which is that the amendment ought to have been allowed. Thirdly, Globemed raises the impact on the trial date, but of course, the 2019 trial date, which has been lost, is a matter of historical chronology, and again plays into the culpable delay analysis, which in our submission is not the right approach. Is coming at the balancing exercise from the wrong place. And fourthly, it said that there will be additional work and cost because it said, well, there's a 4.5-page additional pleading and that it raises complex issues of UAE law. Well, as we say, the reality is it would require a day of legal argument in a trial that's likely to be between 1 and 2 weeks. The second ground of appeal is that the judge misdirects himself in proceeding on the basis of a very late amendment. We refer in this to the decision in Kwa Su Ling, and that is at page 681 of the bundle. We need to look at that quickly. And if I could pick up at page 687.
Kwa Su Ling, the application was made on the day before, just before trial started, isn't it, Mr. Reid?
That's right, my lord. And the principles are set out in paragraph 38. So picking up at the bottom of page 687, the relevant principles can be stated simply as follows. A, whether to allow an amendment is a matter for the discretion of the court. In exercising that discretion, the overriding objective is of the greatest importance. Applications always involve the court striking a balance between injustice to the applicant if the amendment is refused and injustice to the opposing party and other litigants in general if the application is permitted. So that's a fairly orthodox statement of the balance of prejudice. And then B, where a very late application to amend is made, the correct approach is not that the amendments ought in general to be allowed so that the real dispute between the parties can be adjudicated upon. That was the old cobbled approach. Rather, a heavy burden lies on a party seeking a very late amendment to show the strength of the new case and why justice to him, his opponent, and other court users requires him to be able to pursue it. The risk to a trial date may mean that the lateness of the application to amend will of itself cause the balance to be loaded heavily against the grant of application. So where a very late application is made, the balance is loaded against the applicant who needs to explain the reasons for the delay. And indeed, the interests of other court users come into the balancing exercise. And then at C, we have a very late amendment is one made when the trial date has been fixed and where permitting the amendments would cause the trial date to be lost. Parties and the court have a legitimate expectation that trial fixtures will be kept. So where a trial date has been fixed and permission would cause the loss of the trial date. So essentially two elements to that definition. And I should, for completeness, say that D, lateness is not absolute, but a relative concept. So we're dealing here not with very late, but late applications. It depends on a review of the nature of the proposed amendment, the quality of the explanation for its timing, and a fair appreciation of the consequences in terms of work wasted and consequential work to be done. Now, and I should say, I think I suggested that very late implied only during an application made during trial. That was wrong. One sees here that it is limited to circumstances where the trial has been listed and where the amendment risks the vacation of the trial date. But it is worthy of note that there are numerous cases, and as practitioners we are very familiar with them in practice, where amendments are made very late, and there are often cases where amendments are sought during the course of trial. And of course, we are a long way, we're a country mile from that circumstance. And indeed, we refer to the Ahmed case as a good example of that. That is at page 657 in the bundle. Sorry, 654, but if I could take your lordship straight to 657, I'm grateful. So picking up at paragraph 11 on page 657, the trial began on 27th October. Sorry, I should say this is Lord Justice Evans, Lord Justice Moore-Bick, and I'm reading from paragraph 11. The trial began on the 27th of October 2014. At the outset, counsel for the claimants asked the recorder for permission to amend the particular claim to allege that the will had been forged. He did so because it had been drawn to the attention by His Honour Judge Dyte on an earlier occasion that forgery ought to be specifically pleaded as required by the CPR. Fair to say the application was not strongly resisted, although counsel for the defence did seek permission to amend the defence in response. Permission to amend the defence was granted, and an amendment which did no more than put the matter in issue was approved. The defendants made a further application at that stage for permission to adduce expert handwriting evidence, but that again was dismissed. Now, going on to paragraph 13, it will be apparent from what I've already said that the appeal proceeds on the basis that by allowing the amendment to the particular claim, the recorder allowed the claimants at the beginning of trial to put forward a new case which raised issues of fact which the defendants have not had a proper opportunity to deal with, and so put them at a serious disadvantage. If that had indeed been the case, there would have been a strong argument that the defendants had been denied a fair trial. But in my view, to describe it in those terms is to ignore the procedural history to which I've referred. The fact is that almost as soon as the will was produced, the claimants, through their solicitors, made it clear that they disputed its authenticity. In opposition to the defendant's application for summary judgment, they filed the affidavit of Mr. Safdar and the first affidavit of Mr. Hussain, which together made it clear that the validity of the will was being challenged. Moreover, it's clear that the defendants themselves understood the authenticity of the testator's signature was being challenged because they asked Mr. Recorder Chapman at the pre-trial review for permission to call the handwriting expert. There can only have been one purpose in doing so, to assist in establishing that the signature of the testator was genuine and the will validly executed. And then just finally, paragraph 19, at page 659, despite Mr. Brown's submissions to the contrary, the defendants, in my view, were not in the slightest bit taken by surprise in this case. One can see from reading the transcripts of that part of the proceedings which dealt with the matter. The recorder did not allow the amendment because she considered the allegations of forgery were implicit in the particular claim as they stood. She allowed it because it reflected the case which the claimants, to the knowledge of the defendants, had been preparing to make for the previous 6 months. There were, in those circumstances, good reasons, in my view, for allowing the application, and the recorder was right to do so. So this is a very late application, but there is the defendant is not the slightest bit taken by surprise. And so even with a very heavy burden, in the application for permission to amend was allowed. And that is because the court undertook the proper balancing exercise in terms of considering whether there was a real risk of injustice to the applicant. Applying qua in our case, this is not, the nullity point is not a new point. No one is remotely taken by surprise. It was raised squarely in the Dubai court proceedings. It was accepted by Globemed in the JJC proceedings that it was arguable and reasonably arguable that it should be pursued in the Dubai courts, insofar as the JJC ruled that it should be heard and determined by the DIFC courts. That much is plain from the decision of the JJC. Any delay in pleading it in our submission is plainly capable of being compensated in costs. And there is no reason for any heavy loading of the balancing exercise by reference to any either very late circumstances, because there's no trial date that's been set or that is to be vacated, or because of any culpability. Even if there is an investigation into delay in our submission, there is minimal culpability. We accept the early delay in 2018 of a year, and we accept that there are 3 or 4 months of delay while GHS was dragging its feet on security for costs. All of the other periods of delay can be reasonably explained, and there is nothing like the degree of culpability that would be required to deprive the defendant of a complete defense to a $36 million claim. It may be, as I've suggested, that the proper course would have been to stay the DIFC proceedings while the Dubai court proceedings were prosecuted. If Globemed had agreed, which seems unlikely given the position that they were taking at the time, and it may be the case that the DIFC proceedings should have been stayed pending the security for costs application, and indeed that is the procedure that's often followed in England and Wales. But the fault in not seeking those stays, which would, in our submission, have been likely to have been granted, again, we say, is nothing like the degree of culpability that would be required, even on a very late application, in order to prevent or exclude a permission to amend. The delay, even if one applies qua, is just one of many factors. And indeed, if one looks at the L.L.C decision, which is a recent decision of the DIC Court of Appeal, and we have that at 511 in the appeal bundle. This is a decision of the 21st of February, again before the Chief Justice, Justice Roger Giles and Justice Robert French. If I could go to page 517 in the judgment. And if I could just read from paragraph 518, if I could just read from paragraph 27. I should say the applications in this case were applications for late evidence and an amendment, and also I think transfer to part 7. But at paragraph 27, the Court of Appeal deals with lateness. Lateness of the applications without satisfactory explanation, lateness, as the judge saw it, was a relevant matter, but it was relevant primarily for its effect on the disposal of the proceedings in a just manner and in accordance with the overriding objective, not of itself a reason for dismissing the applications without regard to other material considerations. With respect, in his focus on lateness, the judge failed to take account of other considerations material to his decision. And this goes to our point that it's not a question of punishing an applicant for bad behavior. It's a question of considering, looking forward, whether delay will be material insofar as it may affect disposal of the proceedings going forward to trial. And the focus in our submission should be on the future effect of prospective delay, not on punishment for for example, a year of delay in bringing the claims in the nullity point forward in the Dubai court proceedings. And we say that there is a heavy burden to be applied because of the assessment of culpability for past delay. Culpability, indeed, on the assessment of judgment appears to have been reduced to culpability for the JJC application, and it's not the function of the balancing exercise by reference to the overriding objective to punish defendants for applications to the JJC. Lastly, the third ground is the evaluative assessment, which we say are not findings of fact. In effect, it was found that OIC was wrong to issue the Dubai court claim, was wrong to make an application to the JJC, and was wrong to pause while obtaining security for costs. And as you lordships will recall, the court found that there was no explanation for the delay. The culpability analysis and evaluation, we say, has gone wrong, and those three core elements should not have been taken into account. So looking firstly at the Dubai court claim, a claim which on the judge's assessment is adjudged to have real prospects of success as a matter of UAE law, we say that OIC took a reasonable approach in seeking adjudication in the courts of the place of registration, in bringing its claim before UAE judges with expertise in the relevant UAE company law and public policy. In circumstances where there was arguably there was no necessary conflict, that it was perfectly reasonable, therefore, that the company issues should be dealt with in the Dubai courts. As I say, a neater solution may have been to stay the DIFC court proceedings, but the degree of culpability in not formally staying or seeking or making that application would not justify the order.
Mr. Reid, going backwards to the time the MOU was signed, how was that parties did not realize this particular aspect of the law, that the company must be owned 50% by UAE citizen? How's that? Was it intentional?
With respect, they did realize it. We can see that because they are keen to move on to the transfer of shares, and the transfer of shares will be to GMGHS, which will be a UAE entity. So there's clearly a nervousness about the fact that Mr. L.L.C is holding the majority shareholding, subject to a side agreement and a waiver agreement. But the intention is clearly to correct that breach of the nationality requirement of the foreign ownership rules precisely by proceeding with the transfer under the MOU to ensure that the majority shareholding is held by GMGHS, which is the joint venture entity, which will be a UAE company. So I've dealt with the Dubai court claim. In terms of the application to the JJC, in our submission, that cannot possibly have been characterized as being culpable. GMGHS's position was that the Dubai court had no jurisdiction. Now, your lordships will be aware, as a matter by reason of the decision in Lural and Listran, which is a decision of the Chief Justice, Justice Wayne Martin and Justice Sir Jeremy Cook in February of this year, that if the Dubai court had found that the company was a nullity, in circumstances where the DIFC court considered that the Dubai court didn't have jurisdiction, there would be no res judicata in the Dubai court decision. That is the consequence of the Lural and Listral decision. And therefore, we would have had a situation where we had conflicting judgments and where the DIFC court did not accept res judicata by reference to the putative decision of the Dubai court that that the company was a nullity. So in those circumstances, it's precisely the situation where an application to the JJC was necessary because what was needed was an allocation of jurisdiction in circumstances where, as I say, no principle of res judicata would operate. The stay that followed should only have been a stay for 30 working days. That's implicit in Decree 19 of 2016. It's explicit in Decree 19 of 2016. The delay was extended by the JJC by their failure to communicate their decision. But in any event, it had minimum impact on the court users because the application to the JJC, which meant that the trial date was lost, the September 2019 trial date was lost. That vacation happened 9 months in advance. So there was no potential situation of a judge being unoccupied in a trial date. The court had 9 months to find alternative use of the relevant judicial time to ensure that no other court users were inconvenienced and no court time was wasted. And it was implicit in GMGHS's own position, and indeed the JJC decision, that the nullity issue should be heard and resolved by the DIFC court, which is of course is why the application to amend was brought. And thirdly, in terms of the delay pending the security for costs application, well, that delay was a matter of 4 or 5 months. And again, in our submission, that cannot be reasonably characterized as being found to be culpable. There was substantial work in restructuring the claim, not only the re-amended defence and counterclaim, but also the additional claim. And it was entirely reasonable for OIC to want to be sure that security for costs was in place and was in fact paid and that the guarantees were properly provided before incurring the costs. The delay that has resulted in respect to security for costs is a direct result of Globemed's failure to engage, Globemed's refusal of security, its offer of an ineffective Lebanese parent guarantee, and the hiatus that Globemed required in order to put security costs in place. And it is implicitly accepted by Globemed agreeing that they should pay the costs of the security for costs application, that it was Globemed that was at fault. And in our submission, once one takes out of account and one takes out of the balancing exercise those assessments, the culpability of the Dubai court claim, the JJC application, and the delay pending security for costs, once those are taken out of account, then there is, one has an amendment which has real prospects, which requires only a day in terms of argument. And one finds that the balancing exercise that was affected by the judge simply doesn't stand up. The balancing has been distorted by his assessment of culpability and a flawed disapproval of the JJC application. So those are the reasons for which we say the appeal should be allowed and for which we say the decision below is wrong. The matter should proceed to trial on the basis of all issues between the parties, including the issues of UAE law, can be heard and determined by this court on a trial date that has yet to be set.
That's all?
The Lord.
Any questions from the judges? Is 4:25? No, 4:25. What's the time in London? It's 12:25 in Dubai now. Can we take a 30-minute? What? 20 minutes? 20 minutes? How long do we require? 30 minutes break, please.
Certainly.
30 minutes break. We come back in 30 minutes, please, Mr. Edward. How long do you expect to take, Mr. Edward?
I think I'll be between an hour and a half and 2 hours.
Great. So we'll come back in just, 11, 12, just before 1 o'clock. Okay? Thank you very much. Okay, are we ready? We ready? Yes, please.
My Lord.
Yes,
yes.
My Lord, if I just start very quickly with an outline of how I'm going to develop my submissions. I'm going to start with a brief introduction as to the nature of this appeal as an appeal against discretion and the law relating to that, which goes a little further than my learned friend has suggested. I'm then going to look very shortly at the relevant background. I realise that you've all read the judgment and my learned friend has been through it at some length. but there are, of course, different emphases that can be put. But I'll be short and referring almost entirely to the judge's own background. Then I'm going to look at the law relating to the discretion exercised by the judge. I'm going to look at it before I go to each ground of appeal, because, of course, the factors set out in the authorities are relevant to the exercise of the discretion as a whole, and they're not a series of independent tests, save in one respect, that you must meet the summary judgment threshold. As presented by my learned friend, there is a great deal more to the test than he suggests, without, I have to say, going to much of the authority. And then I'll turn to each of the grounds in turn. I recognise also that your lordships have looked at the reasons of Justice Sir Richard Field in depth, but I will have to take you to those during the course of my submissions, because obviously it's important to see what he really did say, rather than surmise as to what was said. So dealing first, my lords, with the nature of the appeal. This is a true appeal against, from the exercise of a very broad discretion of the judge in a case management decision, because that's what this is. It's a case management decision. And there's no suggestion to the contrary. My learned friend has set out what he says is the law on appeals, and we are agreed that it is essentially, or the principal elements are set out in Jopling and Leavesley, and we received the authority overnight, the IDBI decision, in which Justice Martin brought that into DIFC law. But I'll take you to Jopling and Leavesley itself. I should say that the court has given me access to a slightly different bundle than everyone else appears to have access to. Everyone else has the authorities tacked onto the main bundle, whereas mine are in separate bundles. We've tried the link again this morning, and I'm still on the same thing. So I have to add 496 pages to all my authority references. I've tried to do that, but please bear with me. So the first reference is Jopling and Leavesley, which is at page 629 of the bundle, I believe.
Mr. Mark, do you have the benefit of changing between 2-3 different bundles in the system? Because yeah, you might see all of us referring to a certain bundle, but if you go to what I call next to the, let's say, appeal bundle or whatever original bundle, you see a little word change, and if you click on that change, it will take you to the other bundle. There are 3 bundles, and they all available, so you can see everything from that point. I guess.
My lord, I've got everything in hard copy, which I'm using, and I've got all my references. I've got all my references in my notes according, because I only found this out at 7:20 this morning, just before we started.
If you put it back, then no problem.
So I have added, I've been through my notes and added 496 to all my references. So we should be all right.
Yes.
So my lord, it's Jopling and Leavesley, which starts a couple of pages beforehand, but the essential paragraph is paragraph 9 on page 629. Where Mr. Justice Lewison, I think, Lord Justice Lewison, as he was and is, it's common ground that the judge was exercising a discretion. This court, therefore, cannot interfere with the exercise of a judge's discretion simply because it would have exercised the discretion in a different way. An appeal court has to be satisfied that the judge misdirected himself in principle, or left factors out of account, or took irrelevant factors into account, or that he reached a decision that no reasonable judge properly directed could have reached. So there are the 3 factors, and notably they do not include giving the wrong weight to a factor. He must have either left them out or taken account of an irrelevant factor, or his assessment of the weight to be given must have been one which no reasonable judge properly directed could have reached. And that is the same with, as my learned friend puts it, any evaluation that he carried out. It is not for this court to rejudge, to exercise its own discretion or reevaluate, unless it finds that his evaluation was so unreasonable that no reasonable judge could have done so. And as we'll see, he did no such thing. It also has a knock-on effect into the way the grounds, and I'll go to them in more detail later, but if one reads the grounds of appeal, as Justice Martin noticed earlier, they specifically allege failures to consider facts, relevant matters. But what my learned friend has said in submission is that that is not the case, but they rely on the judge being having been unreasonable, so unreasonable that it could not otherwise have been found. Now that is in contravention. If I could take to page 23 of the bundle. This is my learned friend's skeleton argument, and this page, paragraph 55, the content has remained ever since the first skeleton argument was filed. And you'll see at paragraph 55 that my learned friend relies only on the first two limbs of Jopling and Leavesley, either misdirection or leaving factors out or taking account of irrelevant factors. Nowhere in the skeleton argument or the grounds of appeal is it suggested that the judge reached a decision no reasonable judge properly directed could have reached. And yet that forms the basis of my learned friend's submissions this morning with respect to grounds 1 and 3. He does not maintain anymore that as in the grounds, that the judge failed to balance the prejudice. What he says is he failed to carry out a reasonable balance because he came to a conclusion with which essentially OIC does not agree. And the same with ground 3. It is said that he omitted to consider various factors. It is not said his evaluation was incorrect. And yet those are the submissions before you today. They are outside the grounds of appeal in respect of 1 and 3. And we say that's a wholly illegitimate approach. It should then be said that the analysis of this court's consideration of the discretion goes much further than simply as set out in Jopling and Leavesley. If I could take you to Abdullah and the Commissioner of Police, which you will find at page 646 of the bundle. And this is again a judgment of Lord Justice Lewison. The relevant passage is at page 652. It begins on 652 at paragraph 26. He refers to Mitchell and News Group newspapers. And then at 27, the first instance judge's decision in this case was to refuse relief against sanctions, and her refusal was upheld by this court. But the same approach applies equally to decisions by first instance judges to grant relief against sanctions. And then there's a quote from Chartwell Estate agents. The enjoinder that the Court of Appeal will not lightly interfere with a case management decision and will support robust and fair case management decisions should not be taken as applying when 3.9 is in a point, only to decisions when relief from sanction has been refused. It does not. It likewise applies to a robust and fair case management decisions where relief from sanction has been granted. In my judgment, the same approach applies to decisions by first instance judges to strike out or to decline to strike out claims under CPR 3.4. In a case in which, as the judge himself said, the balance was a fine one, an appeal court should respect the balance struck by the first instance judge. As I've said, I would have found that the balance tipped the other way, but that is precisely because in cases where the balance is a fine one, reasonable people can disagree. It's impossible to characterize the judge's decision as perverse. Now that is what we say applies here. Now the judge didn't even consider it to be a fine line, but even if you were to do so, this court should still not interfere. It is simply a robust decision that the judge was entitled to make. And this court should not be interfering with first instance decisions, not least because as it discourages satellite appeals such as this one, where you simply end up going on and on with appeals in respect of case management decisions which have been properly dealt with the first time round. And we say it's impossible in the circumstances to suggest that the judge was capricious or perverse. Now, secondly, my learned friend has made submissions as to what one suspects that the judge might have been thinking, and that might not have accorded with the test. But if I can take you to the Re-C case, which is at page 623 of your bundles. Again, it begins some pages earlier, but the relevant passage is at 623 at paragraph 39. In this situation, it's conventional to refer, as we were referred, to the classical authority of G&G. Nowadays, it's perhaps more helpful to refer to the decision in the House of Lords in Plislowska and Biglovsky. Set out the key passages from G&G and Biogen. He then continued with this vitally important observation. Reasons for judgment will always be capable of having been better expressed. Reasons should be read on the assumption that, unless he has demonstrated to the contrary, the judge knew how to perform his functions and which matters he should take into account. This is particularly true where the matters in question are so well known as those specified in section 25(2) of the Matrimonial Causes Act. Now, I'd suggest that one could equally insert the law relating to re-amendment in the case of a commercial court judge who has sat in the courts in England for many years as a High Court judge in the commercial court. An appellate court should resist the temptation to subvert the principle that they should not substitute their own discretion for that of the judge by a narrow textual analysis which enables them to claim he misdirected himself. And then over the page, so it is not enough merely to demonstrate that the judge has not referred to something. The burden is on my learned friend to show that he actually failed to take account of matters, particularly when they're so obvious as the costs of amendment or something. As I say, the judge is an extremely experienced English commercial court judge. He is also extremely experienced in case management. The commercial court doesn't have any junior level of judges or court officials dealing with directions. The cases are all docketed and managed by the judge himself. And OIC has not demonstrated the contrary, as we'll see. So what you have in front of you, my lords, is however eloquently and at whatever length my learned friend tries to recast it, is simply an attempt to obtain a rehearing of the application to re-amend and to revisit the judge's discretion in a case management decision. My lord, I'll then now turn to the factual background, and I think that can be best done by turning to the judgment. Which starts at page 234, or the schedule of reasons starting at page 234. Paragraphs 3 to 6 set out fairly uncontroversial matters, apart from GMGHS's incorporation, possibly. But we start really where my learned friend did too, at the meeting on the 13th of January 2015, set out in paragraph 8, where the two contracts were executed. Now, I just want to go back very briefly to a point that the Chief Justice made. If one goes to page 320, which is the Memorandum of Understanding that my learned friend took your lordships to earlier, and the second paragraph of the preamble. Now, as your lordship recognised, here we have precisely the factual basis of the re-amendment. It is all taken from this. Nothing was hidden. The relationship, the shareholdings were expressly stated and known to OIC and its legal advisors throughout, and they were content to contract on that basis. And yet it is these facts which they now claim as the basis of their right to resolve from the contract. And it goes further, as your lordship said, they knew all about this for years, as the judge took into account. There was no reason for their delay whatsoever. This is not something they discovered, as is the usual in Kwasu Ling, for example. It was said that documents had been discovered in disclosure, which gave rise to the amendment. This was known to everyone and recognised, as Mr. Kishore admits, at the time they filed their defence and amended defence. While we're here, you will have heard my learned friend say that, or it's also in the judgment, that part of the defence is that the loss is too uncertain because it's a loss of profits. It is too uncertain. Well, if one turns to page 333, you'll see what was Appendix 2 to the Memorandum of Understanding, which is a detailed profit and loss forecast for the first 3 years of the contract. It wasn't that unforeseeable, the loss. They had in fact worked out what it was likely to be beforehand. Going on with the judgment and the background, we see at paragraph 17 the act that has given rise to the claim, and that was that on the 21st of May Mr. Patrick Schoffel, the Chief Executive Officer of OIC, sent the following email to Globemed. As you have heard by now, we have received instruction from our board to cancel our joint activities in respect of the joint venture as well as the TPA Service Agreement. This has taken us all by surprise, and I extend my deepest gratitude to you and your respective personnel for the time, effort, and dedication invested by all. The decision is a strategic one, which has group implications broader than OIC. Now, there we see again, this was not the reason, or the reason for their resiling from the contract was nothing to do with the existence or validity. They're simply trying to get out of a contract which they have decided is strategically inconvenient to them now. Then we see some 2.5 years later, during which the parties have been in correspondence throughout, GMGHS issues its claim for the sum of 36 million. So as it said, the judge has not taken account of the size of the claim. Well, he has. He's expressly stated the size of the claim. It wasn't a surprise to him. It can't possibly be said that this is something he failed to take into account. Then over the page, paragraph 19, you will see, without going to the particulars of claim, the judge recites paragraph 1 of the particulars of claim, alleging that the claimant is a limited liability company and has been licensed in various ways, conducting business, etc., etc. Paragraph 20, following extension of time for its service, OIC's defence was served on the 15th of January 2018. And it was pleaded therein that the TPA agreement had never commenced or become effective, notwithstanding that it had been executed at a special meeting that took place in my client's offices in Lebanon, and that it was conditional on the share transfer contemplated in the MOU having been effected and on the issue to GMGHS of a third-party administrator license. Now, my learned friend made the bold submission, or the way in which he put his submissions this morning, was that there was a condition. These were conditions that had to be complied with. In fact, there was no express condition relating to either of these factors at all. The defence is that these matters were a precondition, but it does not actually appear in the contract at all, either of the contracts. You'll see at paragraph 1, the judge took up the point about the admission of the proper formation and existence of the company in paragraph 2 of the defence. So when it is said that this issue was simply not dealt with, what in fact happened is, even if it is said that they were supposed to go off to a different jurisdiction, that is irreconcilable with the admission that the company was a company in good standing. Now, after the defence had been amended, there was a CMC on the 5th of March 2018 and a comprehensive timetable down to trial to take place on the 24th of February 2019. Unfortunately, during the course of a very substantial disclosure exercise, it became clear that that date would have to be adjourned for a trial. So, Your Lordship asked at the beginning whether pleadings had been closed. Not only had pleadings been closed, but disclosure had taken place on the basis of those pleadings, and that disclosure had taken a year, approximately, after the close of pleadings. So at 24, you'll see that in November 2018, an amended case management order was issued, vacating the trial and substituting the 22nd of September 2019. So at that point, disclosure is done, and we have a trial listed for 10 months' time. And it was not until the 3rd of January that OIC issued a claim in the Dubai courts. What is more extraordinary is that they never gave us any notice of this claim being issued. In all those 11 months, we weren't told about it. There was no suggestion that this claim would be made, no suggestion that this defence would form part of a defence. And you may think that the judge bore that in mind as part of his consideration of whether this was simply to create delay and essentially was an abusive process. Why would we not have got any warning or been told or agreed that these proceedings should go ahead in the Dubai court? Coming suspiciously at a time when the case has now been listed for trial for the second time. 20th of January 2019, we applied for an unless order in respect of OIC's disclosure, and OIC applied to redact. And it was then not until the 30th of January, so almost a month later, that OIC applied to the JJC for a ruling as to where their claim should be tried. Now, we'll go into the JJC's decision in more detail later. Suffice it to say that when they dismissed it, they were damning in their criticism of OIC. And we say that is not something that OIC can simply absolve themselves of as a matter of submission. We accept the parties weren't notified, and for some unknown reason, until 23rd of September 2019. 24th of October, the disclosure applications were settled, and only after that did OIC file an application for security for costs. So by this time, the claim has been going on for 2 years before any application is made for security for costs. The 30th of October 2019, we were told that the defendant intended shortly to seek the claimant's consent to file and serve a re-amended defence. We're not told at any stage that that is being put off to abide the provision of security for costs. It is fair to say that the final agreement as to the form of security was not until the 15th of January. That, as we'll see in due course, we had in fact conceded the principle of security much sooner than that. It's not until 20th of January then that we first see the substance of the re-amended defence being fleshed out, and not until the 23rd of January, some 4 months after it's been threatened, and 5 months after the JJC decision, that we actually receive this document, the draft. So there we have it, that this application was served 3 years after the service of the particulars of claim. And as we'll see, no good reason was given, apart from subjective belief that this was a reasonable delay. And unsurprisingly, the judge was unimpressed by the lack of explanation for that delay. My lords, I'm now going to go to the law on an application to amend, such as was faced by Justice Sir Richard Field. As I say, it deals across the grounds of appeal. It applies across the grounds of appeal. They're not to be considered in isolation. All the factors go into one exercise of discretion, save only that there is a threshold in respect of the summary judgment test, immediate judgment test. But the consideration of the merits, as we'll see, does not stop there. It is not enough simply to say we have got over that hurdle. I don't think there is any dispute that the English authorities have been adopted into the IFC law, and there is no material distinction. We cited the cases of Veggie Bar and Ghaffar to the judge, and there's been no dispute over it. Fortunately, it's an area in which English judges find it necessary to rehearse what everyone else has said previously each time that they wish to refer to it, and then to tack on their own short comment at the end. It's in the bundle. So the decision which holds most of the previous summaries is the Essex County Council and UBB waste case, which you can find at page 663. So it's 661 of the authorities bundle. A decision of Mr. Justice Pepperell. If one turns to page 663, we have the recitation of the law. Before I look at it in detail, you'll see the first case that is essentially recited is the what was said in Kwasu Ling, to which my learned friend referred to the first 4 paragraphs, but stopped at that point. Over the page, we have CIP and CIP properties and Galliford Try infrastructure, on which which says similar but not identical things. And then importantly, as we'll see at paragraph 11, the judge added his own summary, and that is what we will see in due course entirely undermines ground 2 and the difference between late and very late, or any determination thereof. So if I could just start at paragraph 8 on page 663, we see Mrs. Justice Carr's, as she then was, summary. So whether to allow an amendment is a matter of discretion, as we know. In exercising that discretion, the overriding objective is of the greatest importance. Applications always involve the court striking a balance between injustice to the applicant if the amendment is refused, and injustice to the opposing party and other litigants in person if the amendment's permitted. Now, we'll see it even more clearly stated in paragraph 11. But this is not simply a test of prejudice. It is a test of the relative justice, and that is what is done. The test of relative prejudice is simply part of that determination. It is not the be-all and end-all of it. She then continues, where a very late application to amend is made, the correct approach is not that amendments ought in general to be allowed so that the real dispute between parties can be adjudicated upon. So it is not a rule, as my learned friend seeks to promote it to, that you only look at the other factors where it is a very late application. You always look at all the factors. It is just a general rule because, as is said elsewhere, it is more likely that there is prejudice if it is very late, or it is likely that the prejudice is greater if it is very late. But it is not simply a threshold test. Rather, a heavy burden lies on a party seeking a very late amendment to show the strength of the new case and why justice to him, his opponent, and other court users requires him to be able to pursue it. A very late amendment is one made where the trial date has been fixed, and where permitting the amendments will cause the trial date to be lost. We have no dispute on that. Lateness is not an absolute but a relative concept, and that's applying to all lateness. It's not making a distinction between late and very late. It is all a continuum, as we'll see in due course. It depends on a review of the nature of the proposed amendment, the quality of the explanation for its timing. So you have to balance the prejudice against the explanation. It is not just a balance of the prejudice and you put everything else aside. At E, gone are the days when it was sufficient for the amending party to argue that no prejudice had been suffered save as to costs. In the modern era, it's more readily recognised that the payment of costs may not be adequate compensation. My learned friend says that we'll be adequately compensated for the prejudice. That's not the case at all. The most we're ever going to get paid in costs is the cost of this appeal and the cost of the application and the cost of amendment. That is not compensating us for the prejudice that we're caused by the delay which the judge found would be caused. It's incumbent on a party seeking the indulgence of the court to be allowed to raise a late claim to provide a good explanation for the delay. And a much stricter view is now taken nowadays of non-compliance. A couple of sentences down, parties can no longer expect indulgence if they fail to comply with their procedural obligations. And then over the page, the judge referred to the wider public interest of ensuring that other litigants can obtain justice efficiently and proportionately, and we'll see that was one of the factors the judge also took into account. We then go to the CIP Properties and Galliford Try case. Now, I accept that in some way these are similar, but they do have their own emphases. Again, the lateness by which an amendment is produced is a relative concept. An amendment is late if it could have been advanced earlier, or involves a duplication of cost or effort, or if it requires the resisting party to revisit any of the significant steps in litigation, such as disclosure, provision of witness statements and expert reports. And I'd include in that pleadings. Of course they do. An amendment can be regarded as very late if permission to amend threatens the trial date, even if the application is made some months before the trial is due to start. So that's in line with my learned friend's concession, and we accept that that is what very late is. The history of the amendment, together with an explanation for its latest, is a matter for the amending party, and it is an important factor in the necessary balancing exercise. In essence, there must be a good reason for the delay. Now, I'm not going to rely too heavily on the word must there, because as he sets out in paragraph 10 below, he refers to this passage being cited in Vilca and Extrata, and Mr. Justice Stuart Smith, as he then was, saying, although he said that he did not agree with Coulson J, that there must be a good reason for the delay. I agree with that caveat. We do not rely on it being a threshold test, but it is clearly a very important factor in granting permission for the re-amendment, however late it is. Of course, it may not matter much if the amendment is done very soon after pleadings are originally done. But it is simply a matter to be taken into discretion in the broad continuum. Particularity and clarity of the proposed amendment has to be considered. We accept that. Then the prejudice to the resisting parties, if the amendments are allowed, will incorporate at one end of the spectrum the simple fact of being mucked around to the disruption of an additional pressure on lawyers in the run-up to trial and the duplication of cost and effort at the other. If allowing the amendments would necessitate the adjournment of trial, that may be an overwhelming reason to refuse the amendments. So again, this is not saying it's the only reason. It's just saying that in many cases, that will be the overwhelming reason. But finally, prejudice to the amending party, if the amendments are not allowed, will obviously include its inability to advance its amended case. Now, my learned friend says that the judge, as we'll see, did not sufficiently take account of the impact on OIC of not permitting their case. We'll see he expressly took it into account, but it is absurd to suggest that he did not take into account that this prevented them from running the amended case, or the case as amended. But that is just one factor to be considered. Moreover, if that prejudice has come about by the amending party's own conduct, then it is a much less important element of the balancing exercise. Now, this is something with which my learned friend has entirely failed to grapple. He is going to need to get past ground 3 before he can possibly say that any prejudice that OIC has caused to its, well, all prejudice to OIC has been caused by its own conduct. And therefore, it will be much less important element in the balancing exercise. So what we see is not a balancing exercise between the relative prejudice. That is not enough. One has to go much further. One can discount the prejudice if it's been caused by the party's own conduct, for example. Lateness is important in assessing it. You can't just say, we suffer more prejudice than them, that's it. That's my learning friend.
Why do you say that the conduct of the defendant caused its own prejudice?
Because it is the one that caused the delay. It has been responsible.
But that's only if you regard the delay as fatal. This argument is entirely circular, isn't it?
No, what I'm saying is he needs ground 3.
The prejudice is the consequence of the delay. Therefore, the delay was caused by the respondent. Therefore, you don't take you exclude it.
He will need
that assumes that delay is a decisive factor. Now, delay is a given because you're only talking about this because the amendment is late. So, I'm just not following the relevance of this argument, I must admit.
Well, it's because there may be reasons, but if it has been deliberate, for example, I mean, I can take it no further that it is relevant if the delay has been caused, the prejudice has been caused by that person. It may be part of the same thing. But it's
the prejudice, the defendant didn't cause prejudice to itself. It only suffers prejudice if the court refuses the amendment. The defendant caused delay. So the question is, what is the consequence of the delay? Now, of course, there's always some prejudice to all parties by reason of delay. That's what the authorities say. But when you're looking at the balance of injustice, which is the critical, Justice Pepperell says, on my view, there's only one rule, it's the balance of injustice.
Yes.
So therefore you say, well, the balance of injustice is if the amendment is disallowed, the defendant is denied the opportunity to put before the court an argument with real prospects of success, which, if successful, would defeat the claim. Now, the injustice to the claimant is that it is confronted with an argument later than it should have been confronted with it, and it has to deal with it. Now, how can you say that there is a reasonable balance between those two competing factors? Surely the prejudice to the defendant greatly outweighs, or the injustice, to use your word, Justice Pepperell's word, surely the injustice to the defendant greatly outweighs any injustice to the claimant in those circumstances.
Well, no, because you can't simply conflate the prejudice with the injustice. If the delay is unexplained, then it is no longer unjust to shut that out, even if the prejudice is greater to one party than the other.
Well, unexplained delay doesn't cause injustice. Unexplained delay is only a source of injustice if it occasions prejudice. Sure.
Well, as the judge found, part of the prejudice had already occurred because this was a continuing abuse, as he saw it. It was a deliberate.
Well, let's leave that to one side because that's contested. We're just at the moment talking about delay. I'm just not following your argument, I'm afraid, because it just seems to me that when you put these two matters in the scales, you've got a party who comes along late. That's a given. If he hadn't come along late, there wouldn't be any argument. But then you've got a party. Justice requires all properly credible arguments to be considered by the court. So that's the first point. Justice involves the court determining all the issues between the parties. To shut a party out of advancing an argument is, on its face, the source of injustice, because the court is not then determining all the issues as between the parties. And in this case, it's injustice because it is a defence that has real prospects of success. So then you say, well, what's the injustice on the other side? And the injustice is that they're confronting an argument at least 1 year, perhaps later, than they would otherwise have confronted it. But that doesn't seem to me to be itself significant injustice.
Well, the injustice is that you do not get your judgment when you should have done.
Well,
which is an important factor, because you would have had your trial earlier.
But that's not right on the facts of this case, Mr. Knight, unless you attribute blame to the defendant for going to the Dubai courts to contest the incorporation of the claimant. At the time the application was being considered, there was no trial date, and the difference between the allowing the application and disallowing the application made no difference at all to the date upon which judgment would be obtained. Did it?
Yes, because pleadings have already finished and disclosure has already taken place, and it will need to be repleaded, reanalyzed, repleaded, and further disclosure take place.
Well, why would there be any disclosure on this issue? Wasn't it?
Because all they have at the moment is a statement of the ownership in the MOU. That's what it's taken from.
Well, isn't that enough?
Well, no, because the arrangement may not be as they see it. It may be characterized. All it says is he held it on behalf of them. On behalf of them is not a legal term. We need to actually look at the underlying documents, see what the relationship actually is, and take it from there. And it is not, as we'll come to, it's not simply a matter of a day's argument that we've already had. There's a great deal more to it. But that's to look at the specific again, because what all these things are saying is you can't simply look at the prejudice. You have to balance the prejudice against the reason why it's late. Otherwise, there'll be no importance in explanation, because you're simply looking at the prejudice. And instead of the explanation being an important factor, it wouldn't be a factor at all, because you're just looking at whether there is prejudice or not. So my learned friend puts his case expressly on the basis of a balance of prejudice. That there was, well, his ground of appeal is that there was no balance of prejudice. But A, that is not the right test, because justice, notwithstanding the balance of prejudice, can operate against the applicant to amend. Because of their lateness, because of the proper administration of justice, and because of its impact on other litigants. And we'll come to one further aspect when we look at Suling itself in just a moment. Now, paragraph 11, as your lordship has just recognised, there is essentially one rule. It's the balance of injustice, and both to the other party and to litigants in general, if the amendment is permitted, that accepts that all moving around times and dates all impacts on others. 11.2 is really then the fundamental passage. Plainly, the earlier the amendment is sought, the more likely it is that the court will conclude the applicant's interest in being able to argue its case in full outweighs any prejudice to the opponent or to litigants in general. Conversely, the later the amendment is made, the more likely it is. Then he says in the next sentence, not so much because there is some special rule in such cases, but because the obvious prejudice to the opponent and to the administration of justice in losing the trial date often weighs more heavily in the balance than the prejudice to the applicant in refusing the amendment. So with respect to ground 2, as we'll see, there is no material distinction between late and very late. They're simply labels to be used, which are convenient, but not determinative. I do then just want to turn to Hua Su Ling, which starts at page 681 of your bundles. And then if we could turn to page 687, I believe it is. You'll see at the bottom of that page, the judge refers to the principles, and those are the ones, A to G, that I've just been through. The judge noted at 39, the commercial court has a long tradition of proactively managing litigation brought before it for the benefit of all users, and that was expressly relied on by the judge in his judgment. Now, without going too much into this judgment, because it is simply an example, but at paragraphs 40 to 49, the judge sets out essentially under two heads, the importance of culpability for the delay. It is a factor of its own. You must take into account in assessing the justice, and we say that's exactly what this judge did, and anything else is simply re-exercising his discretion. He was entitled to take the reason into account, and unless it can be shown that his reason was so unreasonable that no properly directed judge could have done it, that is unappealable. Page 690, paragraph 57. The judge makes clear how important the strength of the case is. I turn to consider the strength of the new case. GS does not contend outright that it has no real prospect of success, rather that it's not sufficiently strong to justify permission for a very late amendment. So getting over the summary judgment or immediate judgment hurdle is not enough of itself. The court is then entitled and must look at the strength of the case. And as we'll see, the judge's opinion was that this only just overcame the summary judgment test. It was barely more than narrowly more than fanciful. And he was perfectly entitled to take into account that this was a poor case which was going to cause prejudice in any event. And then we see on page, it's my page 199, paragraph 94 and 95, page 15 of the printout, the original printout. The judge sets out her view, considering how the balance should be ultimately struck, or how the moving parts should be put together. In light of the scope and the nature of the proposed amendments, the weakness of the new case, the poor quality of the explanations for delay in advancing it, and in any event, the lack of any good reason for such delay and the prejudice resulting to GS, I'm not persuaded that it is just a proportionate outcome that the amendment should be permitted. Everything has to be looked at, not just the prejudice. And in the absence of other factors, the judge is perfectly entitled to exercise his discretion to disallow amendment. My lords, there I turn to, I'm sure you'll be pleased to hear, I turn to the first ground itself. As I say, it's important to establish what this first ground of appeal actually is. If we turn to page 4 of the bundle, where the grounds are set out, what is said in the grounds of appeal, which have not been amended, and there's no application to do so, 1.1, the learned judge failed to consider the relative prejudice to the parties. That is an absolute. It is not a matter of his giving the wrong weight to various factors. It is said that he failed to do so. Now, if one looks at OIC's original skeleton argument in support of their appeal, which was filed with the appeal, page 75, the heading remains, there was a failure to balance the prejudice to the parties, which is in line with the ground. And then it said, notwithstanding the judge set out at paragraph 41 of the reasons that the court should have regard to the impact of granting the application on JHS and the impact on OIC if the application be refused, the judge failed to do so. Now that is not, he did do that. He directed himself to do it, and he did do it. On any basis, he assessed the impact on the parties, as we'll see when we look at his judgment. But I'm sure it's clear already. He did not fail to do it. If one looks at the reasons, the judge's reasons, sorry to take you between documents, so I'll come back to the skeletons. But on page 244, I'm sorry, that's simply the quote where he has expressly directed himself. So it can't be said he misdirected himself. It has to be said that he must have left something out. But of course, that's not the ground of, well, he's not supposed to have done any of this. But we'll come back to see that he did in due course. The third limb, as we've seen, was not relied on. So we're left with the second. Now, the original skeleton continues in paragraph 55 that he failed to do so, and on grounds that the judge, in failing to consider the relative prejudice of the parties, misdirected himself in principle and/or left factors out of account, and took irrelevant considerations into account, this appeal should be allowed. So that again, that is relying on the first two limbs of Jopling and Leavesley. Sorry, my lord, I just don't want to repeat myself. So if we turn to the judge's reasons, now is a good time to go through his full reasoning. So starting at page 252. So it being said that that the judge failed to consider or balance the relative prejudice. Here we have at paragraph 62, his express consideration of that argument, or a part of that argument. In addition, Mr. Reed argued that GMGHS would suffer no prejudice if the re-amendment were allowed because it was not very late. And then he refers to Kwa Su Ling. No pretrial review had been listed, there was no current listed trial date, and GMGHS must have appreciated since 23rd of September that OIC would be applying to plead the nullity point that had been raised in Dubai proceedings. So he has looked at all these factors. Accordingly, it is said by Mr. Reed, it would be unjust in these circumstances to shut OIC out from advancing its nullity claim. It then deals with the submission that the court's interests were not to be recognised. But in my submission, the judge has clearly, and my learned friend simply cannot demonstrate that the judge has not taken these factors into account as he was obliged to do. 64 and 65, he dealt with the withdrawal of the admission, but he then turns to the substance of his decision at 66. And he has three reasons. OIC had 3 years after it renounced the TPA agreement to consider what defences it might have. It's plain from the evidence contained in paragraph 32 of Mr. Kishore's fourth witness statement served by OIC that OIC took a conscious decision not to plead the nullity point when it served its defence. Obviously, we'll be coming back to these in due course, but I'll take you to them now. OIC then let almost a whole year go by before seeking to have the nullity point decided in the Dubai courts, which step led to GMGHS's claim being stayed for almost a further 10 months. As a direct consequence of the delay resulting from OIC's Dubai proceedings, the second trial date fixed for the 22nd of September was lost. Now that may already have happened, but it was part of the same, as the judge saw it, part of the same series of, or part of the same conduct. As already recorded, the JJC concluded that OIC had created a jurisdiction dispute solely for the purpose of avoiding, and this essentially paraphrases the JJC's decision, or at least delaying the resolution of GMGHS's claim, and nothing has been put before me that goes anywhere near to displacing that conclusion. It follows, in my opinion, that it would be contrary to fairness and justice for this court to condone OIC's conduct in launching the Dubai claim when it did, and to allow it now to plead the very same nullity claim when its conduct was directly responsible for GMGHS's case not being tried a year ago. Further, and in the alternative, even if OIC's main purpose in bringing Dubai proceedings was not to avoid or delay the resolution, the unexplained omission of OIC to plead the nullity point, OIC's delay in waiting for a year, and the issuance of those proceedings which was bound to lead to a stay, all constitute conduct that renders it unfair for OIC now to be permitted to plead its nullity claim. He has clearly balanced the justice within his discretion. So my learned friend has to show that he has done so in a matter that no reasonable judge could have done. That is not an allegation which has been made in the grounds of appeal or in my learned friend's skeleton argument. It has been made today for the first time, and even then only in a roundabout manner. The skeleton argument explicitly said that that was not one of the grounds relied on. Um, 68, the judge went on to discuss the effect on other court users, and then 69 about the culpable delay and no justifiable basis for OIC to abstain. And OIC engaged in correspondence threatening re-amendment shortly and as soon as possible for all those reasons. So he was absolutely convinced, having weighed up the relative prejudice, that the justice of the case, and that is the test, the justice of it, not simply the balance of prejudice, weighed in favour of my client. And we say that makes it a proper exercise of his discretion, even if it is one which may reasonably be disagreed with. So unless my learned friend gets over ground 3, ground 2 cannot assist, ground 1 cannot assist him. And we can see the difference in my learned friend's case in his current skeleton argument on page 25. In fact, on page 23. The case put in the skeleton argument, paragraph 56, changed from failing to carry out a balancing exercise at all to failing to carry out a reasonable balancing exercise of the prejudice to the parties. Now that is a wholly different thing and must be one that is so unreasonable as no judge could have done it. And it isn't actually the ground of appeal. My learned friend, paragraph 60 over the page 125, even concedes that there has been an exercise, a balancing exercise. He just says it's gone badly wrong because the judge shared the negative view of the JJC on which it sat. My learned friend also relied on the Chief Justice's judgment in fixed sense management. A postscript in that judgment I'm afraid I have not added, if I have 500 pages, it should be about page 527. 524. The fixed sense management case. Do your lordships have it? Okay, cool. Paragraph 29, page 29, the postscript that my learned friend has referred to.
It's at 525 in the bundle. No?
I'm grateful. The postscript, the 3 short paragraphs, what there is actually relating to is on summary judgment or immediate judgment, that where immediate judgment has been refused, it is pointless having appeals because you're going to go on anyway, as opposed to the other way around where it has actually been definitely struck out. Now, that's all very well, and as it should be, but with all due respect to the Chief Justice, it is wholly irrelevant because we have already dealt with the summary judgment test. Nobody is complaining about the summary judgment test at all. We have moved on from there and we are looking at the relative prejudice and the justice of the case in the round. It really doesn't assist my learned friend to discuss the appeals of summary judgment cases. This case takes that as a given. Now, we say that's enough to deal with this point. However, a number of subsidiary grounds are relied on by my learned friend in support of ground 1, possibly because of the difficulty of getting around the fact that the judge has, in fact, made a decision and balanced these factors. We're left with the formulation at paragraph 58 of the skeleton on 24, that the judge erred in failing to take into account the following critical points. And we then get the points at 50, we get 4 points at 58.1, 2, 3, and 4, with some subsidiary points as to the context. But if we go through 58.1 to start with, the judge did not possibly fail to take into account that OIC would be prevented from raising a complete defence to GMGHS's claim. That's exactly what a day of argument was about. Nobody suggested it was a partial defence. Nobody suggested anything other than this would be fatal. If it was refused, it would be fatal to that argument. Nobody suggested it could be pursued elsewhere. It's worth saying the claimant already has 2 other complete defences on which it relies, and presumably it maintains that those are also good. And it shouldn't be that prejudiced by not being able to rely on this one if it has 2 good defences already. It deliberately chose not to pursue this one at the time. And quite apart from anything else, as Mr. Justice Coulson, as he then was, said in CIP Property and Galliford Try, it is obvious what the effect of refusing the amendment was, and it's absurd to suggest that the judge did not have it in mind. However, that might be an appropriate place to look at the actual merits of the nullity case. And these we will see from paragraph 57, or at paragraph 57, at page 250 of the bundle, paragraph 57 of the reasons. Does the claim proposed to be pleaded by OIC have a real prospect of success, notwithstanding the points made by Mr. Knight? After much anxious consideration, I have concluded that the proposed claim does, albeit by a narrow margin, satisfy the real prospect of success test. And he then says why. Now, the real prospect of success test is a notoriously low threshold. It only requires it to be more than fanciful. And even on that, the judge had doubts. It is not a good case, as my learned friend says. It has a narrow prospect of success. Now, that's not surprising when my learned friend boldly says that contracts made with companies which are illegal, as he puts it, are automatically void. That is not the case. We had an argument all day, and the judge did not decide that that was the case. There was a great deal of discussion, as you'll see on pages 245 to 246, about the implications of Article 16, which was heavily relied on by my learned friend as their right to evade liability under the contract. Because a third party may hold to the existence or the invalidity of a company against the shareholders. And they then go to another clause, which I can't remember exactly, which says that contracts which are invalid will not be enforced or are void. However, Article 16, as the judge was receptive to in argument and in his judgment, makes 2 contrary provisions. If the company is deemed void against a third party under Article 16(2), persons who contracted with such third party in the name of the company shall be personally and jointly liable for the obligations arising from such contract. That presupposes the continuing existence of the contract. The contract is not void. And that is how the de facto company arrangements come in. And 3, in all cases where the invalidity of the company is ruled, The conditions set forth in the memorandum shall apply to the liquidation of the company and the settlement of the rights of shareholders against each other. The debtors of the company may not request the invalidity or hold thereto in order to be discharged from their debts to the company. Now, if contracts were void, they could not do so. There is express provision for debts to continue. And that is what we heavily relied on. And as the judge said, that was the principal reason why he had such doubts. OIC was driven to arguing that they, as a person making the application for a declaration that the company was illegal, would be the only debtor to be released. They could rely on it because they made the application and no other could. And the judge goes through that at paragraph 46. It is not a good case at all. And the judge was perfectly entitled to take that into his consideration when deciding whether the justice of the case allowed it to go on. The passing the summary judgment test does not promote it to a good case. Sorry.
Mr. Knight, if we are assuming that we decide to grant or allow the appeal and grant appellant to make amendments, those questions will again be decided at the trial, isn't it?
Yes.
The same issues that you raised on Article 16 will be re-argued.
Yes.
And then you would have the opportunity to reply or to also argue.
Yes, of course. But we'll have to put in our defence. We'll have to go through disclosure, and we'll have to wait for trial in due course. But what we say is that's always the case if it was basically refused.
But the other factor that's I'm thinking of is the fact the amount of the claim involved is $36 million. Shouldn't that be a factor that the appellant should be given all the chances to defend his case?
Well, that's simply a re-exercise of the discretion. It is certainly a factor.
It's a factor.
And this judge, the size of the claim is a factor. And the judge knew the size of the claim. And he decided, notwithstanding that, he was not satisfied this should go forward. But that is merely to re-exercise the discretion. You don't have to agree with the judge.
But your argument
this
that
may well have done something different, but unless
we should not interfere with a decision of a judge who have taken everything into consideration when making his decision. That's your case, basically.
Yes. I mean, unless he was so unreasonable when he assessed this.
That no other judge in his position would have made a similar decision. Yes, understand that. Yes, please proceed. Thank you.
Thank you.
Sorry.
And I say in passing, I've said it in my skeleton argument.
I your train of thoughts. Okay.
My learned friend keeps referring to this being a complete defence. As I say, nobody's ever suggested the contrary. Of course, it's a complete defence. And it doesn't add anything to being a defence. Nobody suggested it was partial at any stage, and nor has the judge, in his judgment, made any contrary finding. As I say, the judge was clearly aware of all the matters relied on in the context. The reasons note the size of the claim. Nobody suggested there was any alternative forum. The judge proceeded on the basis that this was it. He was shutting it out completely. The decisions are premised on the decisive impact of his decision. It's also said that we are being in some way unfair because OIC would have been entitled to a large proportion of the sum because it would become essentially half owner of GMGHS. That is true, but it derives from OIC's own default in not taking the shares that it could have purchased for $1. It has left GMGHS, with whom it contracted, in somebody else's ownership. That is the consequence of the contracts that it made and broke. Now, it may be that it has some other defence, and as the judge said in his reasons at paragraph 103, in my view, this means that the case should now be managed to come on for trial as quickly as possible at the hearing, of which it will be open to OIC to contend, in addition to any other damages arguments it may have, that under the UA law of damages, account must be taken of what the overall outcome would have been if the connected transaction had been performed in accordance with its terms. It's already in their defence. It is not shutting them out at all from that. If they
Excuse me, Mr. Nat, excuse me. Can you explain to me a bit on the $1 payment consideration?
Yes,
I'm not very clear on that.
So there were the two contracts. There's the services agreement between GMGHS and OIC, and then there is the Memorandum of Understanding, which was a contract between OIC and the owners of GMGHS to sell a large part of the shares in GMGHS to OIC for $1.
Yes, understand that part. And
But
that the sale never went through. You see, the sale never.
No, I don't think it's in evidence yet, but
I see.
It will be at trial. But the OIC did not take up what would have been a binding contract on us. They said we were abandoning both when they resolved from contracts. They abandoned both and did not purchase. They could have purchased.
No, the Justice Fields talk about the peppercorn contract. So, you know, that you don't have to pay because it's the token payment that is deemed to have been paid. But for your case, he didn't accept that.
Well, they didn't take. I think there are provisions that something has to happen. And we said, are you coming for these shares? And they didn't take them. I mean, it is a matter which will be in dispute in due course. But essentially, they did not take the shares and made no effort to do so. And they accept they never bought them. But we certainly never refused to hand the shares over.
My lord, I hesitate to interrupt Mr. Knight, but just very quickly to point out, to correct him, that OIC is not in fact a party to the Memorandum of Understanding because it was a putative shareholders agreement.
Sorry,
the party was Synergized Services. OIC signed it in approval because it would not have been one of the shareholders.
You're quite right.
I'm grateful.
Obliged. Now, my learned friend also relies on the absence of any impact on the trial date. Obviously, this is trying to bring it within the late, very late distinction. But it is fair to say that the reasons do not rely on the absence of future impact on a trial date. I think I've got that the right way around. It is not something that the judge did not find that a future trial date was going to be impacted. Only except insofar as the additional work would inevitably delay it and the proper administration of justice. He was satisfied that it was unjust in any event. He knew there was no trial date set. He didn't make a mistake in some way. He didn't take into account that a trial date, he didn't believe a trial date to have been set. So again, it comes back to the exercise of his discretion. He did take these factors into account. Was he so unreasonable that no judge could have done it? In all the circumstances, not just looking at each point on its own, that may seem, well, I wouldn't have done something. The whole discretion has to be re-exercised. Now, that said, as the judge did say in paragraph 66, one trial date had been lost. Now, this is all part of essentially ground 3, but the judge did see OIC's conduct as all part of a piece, and that this application was simply part of associated with the previous attempt to obtain delay, which was going to mean yet more delay. And what he did not want to do was reward that, which couldn't be compensated in costs, the loss of that previous hearing. And that hearing would have taken place without the amendment. There should have been a trial at which the amendment had not been pleaded. Sorry, I can see you moving towards your microphone, Muller.
That's not quite right, is it? The hearing would have taken place if there hadn't been an application to the Dubai court. Is a more accurate way of putting it, isn't it?
Yes.
Thanks.
My lord, it was the application to the JJC that required a stay.
Right,
Yeah,
stay.
well, the application to Dubai court and the corollary was then the application to the JJC.
But yes.
Sorry, yes, that's what I was intending to mean. But it is all part of the same thing, and the judge did not want to reward that abusive conduct and essentially allow OIC to have, as he saw it, and we say rightly, conducted itself abusively and retain the advantage of it without any consequences to itself. And that is something that we say he could certainly take account in looking at the justice of the situation, particularly, as I say, when the trial would have gone ahead without the amendment.
Mr. Knight, do you dispute the proposition that the ordinary course of events is that one would bring litigation with respect to the corporate status of a corporate entity in the place in which that entity is incorporated?
Well, it depends. Not if you have an exclusive jurisdiction clause.
Yeah, all right. But let's forget about the exclusive jurisdiction clause. If you leave that out of the equation, do you accept that there'd been no exclusive jurisdiction clause? The proper course would have been to litigate issues with respect to the corporate status of the claimant in the place of its jurisdiction, in the place of its corporation.
I'm not prepared to make that concession in this case.
Well, do you have any argument to the contrary?
Not being a Dubai law expert, no. I don't have submissions to make on that today.
Thank you.
We then move to the additional work and cost. There's no indication that the judge considered this in any manner other than one would expect. We say it's woefully naive to say that it will be minimal, and it's primarily a short point of UAE law. It is primarily a long point of UAE law. It matters on exactly what the relationship is. Now that the law has been changed and we do understand it no longer to apply, it is likely that the company will no longer be susceptible to being wound up or being found to be illegal now. Those will all have implications for it. The precise mechanism will have implications. They all need to be investigated. If it took 4.5 pages to plead, it involves more issues than my learned friend is prepared to say. And I would say, in a passage that my learned friend skipped over when looking at my skeleton argument from the application, we did make expressly clear in an NB under paragraph 30 on page 212, for the purposes of this application only, GMGHS assumes there's a dispute over validity that is not suitable for summary determination, which will depend on a factual analysis of evidence not before the court. We took one simple point in order to test the immediate judgment test. This was not a full trial of the issues that arise. We took one point that was susceptible to immediate judgment. or the same test. And we very, very narrowly failed on it. But it is just not true to say that the issues were so discrete that GMGHS could raise them without evidence by way of a skeleton argument. And my learned friend has repeated today that this was the first time we raised our argument. We didn't have a defense. It was the place to raise these matters because it hasn't been amended yet. We don't have to respond to their pleaded case except in our skeleton argument as part of the application. As we say, it's going to require disclosure, so we have to go through that stage again, and close analysis of the underlying position. And remember, just dealing with that one point took the best part of a day. Just one small argument in relation to it. My lords, I believe the final point that is made against us is that the other proceedings were struck out, and that would in some way make it unfair. It is not unfair if you have no claim to have your pleading struck out. It does not make your absence of any other case better simply because you were struck out on something that was bad in law and therefore has no prospect of success. That's in the judge's reasons on page 258 at paragraph 81.
But the point, I think, Mr. Knight, is that it all goes back to this question about the choice of the Dubai court, which is why I asked you that question. So what as I understand the defendant is saying, we went off to the Dubai court thinking that was the appropriate place to go to challenge, to raise issues with respect to the incorporation of an entity incorporated in not in the DIFC. It transpires we got that wrong because of the exclusive jurisdiction clause. The consequence of us getting it wrong was a decision by the JJC to the effect that the proper place to raise that argument was in the DIFC proceedings rather than in the Dubai proceedings. So then, after you had arranged to provide the security for costs in the Dubai proceedings, they promptly raised the point in the Dubai proceedings, which is where the JJC said they should go, to be told, no, you can't come here. So the impact of it was they started in one place, perhaps on a reasonable basis, not thinking that the exclusive jurisdiction clause would override that, and then they get snookered. They've got nowhere to go. Isn't that's the point that's being made, isn't it?
Well, that's the point that's being made and the point with which we disagree.
Well, why?
Because they went to the Dubai court after a year already, and the judge was perfectly entitled to find that they had deliberately delayed for a year. I mean, I'm coming on to Ground 3 now, or was going to in a moment, and I'll go through it in more detail there. But they delayed for a year in the first place, and the JJC, having looked at their case in detail, the 7 members of the JJC unanimously condemned what they had done.
But then the result
of that... It's not for me, my lord, to sit here saying, actually, they're all wrong.
But the result of the condemnation, in the events that transpired, the result of the condemnation was that as a consequence of picking the wrong court, their argument they are precluded forever from advancing the argument.
No, it is partly due to that. It's partly due to the first year's delay. It is partly due to their abusive behaviour there. And it is partly due to their failure to have any good explanation for not subsequently doing it immediately and for waiting another 5 months.
We're going to come into that. I mean, I must say, I would have thought where there's an outstanding application for security for costs and the security hasn't been posted, that provides a reasonable explanation for not doing anything, I would have thought. But you're going to try and persuade us otherwise, I'm sure.
Well, A, I'll try and persuade you otherwise, and I'll B, try to persuade you that it is not a decision that the judge was not permitted to make. You may disagree with him.
But that's not a discretion. That's not a discretionary decision. That's a decision that's either right or wrong. that the allocation of responsibility
you-
for delay is not a
But if he's
discretionary.
wrong, you've got to decide that he is so wrong, that he is wrong.
No, just wrong. It's not. That's not a discretionary decision. It's the evaluation of conduct. And if he's wrong on that, and he's taken that wrong decision into account, then he's taken into account an irrelevant factor.
Yes.
That's the problem with all your argument about us having to not only overturn the decision but be rude to the judge at the time we do it. If under, and I think you made this point earlier when you said that ground one depends upon ground three, and I think you're right. But if we find that the judge erred in, under ground three, we find that the judge erred in wrongly allocating culpability, then it follows in the conventional principles in the Leavesley, Jopling and Leavesley, that he's taken into account an irrelevant consideration, being his wrong decision with respect to the allocation of culpability, doesn't it?
Yes.
All right.
Mr. Knight, if you may allow me for this question, what you're going to say about this point? I mean, someone would assume that the JJJ decision has directed the DIFC court to grab on with the matter, to deal with it. Okay, there is a matter of nullity, so it is to be tried before the DIFC court shortly after, if someone to say within a reasonable time, during the discussion of the cost application, it was brought to the judge. So the judge has to follow that, what could be a binding decision of the JJC, and this matter got to be tried before this court because it was transformed from court to another through an authoritative tribunal.
Well, there's been no argument that that is the case, and I don't believe it is the case, because this judge, the principles on which he was to decide it, are not in dispute. Well, they're in some dispute, but it is agreed that is not one of them. It is not said that he was under an obligation owing to the JJC to permit it.
I see.
The JJC were not taking into account all the other factors. They weren't looking at the reasons. They weren't looking at previous delay. They weren't looking at subsequent delay. They weren't looking at the strength of the case, for example.
Yeah, maybe it's not their business. I agree. Yeah, but...
I'm sorry.
Yes.
Ali?
No, I said yes. It might be that true. It's not the JJC's business to grapple with all of these things. They just need to decide the jurisdiction. But I think they have gone far than that even. Anyway, just Martin.
Yes, Mr. Knight. Of course, Mr. Reid says that the judge was wrong to act upon the observations made by the JJC. Do you say that the observations made by the JJC arriving at its conclusion are binding on this court or not?
Yes, I do.
You do. And what's the process of reasoning that leads to that conclusion?
Because this was an application made to the JJC in a matter between these parties, and it is binding on the parties.
But the conclusion is binding, the reasons aren't, are they? So the damning observations, why would this court be bound? Of course the court is bound to respect the conclusion, and there's an issue estoppel with respect to the conclusion. But there's no issue estoppel with respect to the pejorative description of the defendant's conduct, is there?
No, but they did dismiss it partly on that bit. Well,
yes. I mean, the result is binding, but the pejorative observations aren't. I think that's right.
Well, that's not quite true. I mean, it isn't just a matter of a paragraph tacked on at the end. They are. No, I mean, the substantive cases, there's no jurisdiction.
Yes. All right. Thank you.
And that decision we say is binding, yes. But what we do say is that the judge was entitled to take that into account. I'll come on to it in the course of my submissions. In fact, sorry, I will come on to it. I just want to finish ground one. I was just talking about the strikeout related proceedings. And I think, my lord, we're agreed. Well, I'm not sure we're agreed, but this ground very largely depends on ground three. Really, if my learned friend doesn't get over ground three, this ground has no prospect of success. That should be dismissed. Ground two, my lord, is the distinction between late and very late. I don't want to go through that in too much detail. I dealt with it at some length whilst going through the authorities. There is only one rule. Late and very late are convenient labels to determine a general rule, but it is only a matter of likelihood.
Really, ground two is just another way of saying ground one, isn't it? And that is saying that the factor of the in the balancing equation to which ground one, not the balancing exercise to which ground one refers, there was no weight to be, there was no factor to be applied in that balancing in the form of a lost trial date. That's really all it's saying, isn't it?
Yes.
So it's just repeating.
It is going back to the balance of prejudice. It is said in the authorities that lateness really just goes to the prejudice.
Yeah. All right. Well, speaking for myself, I don't need to hear any more about ground two, but I don't know about the other members of the court.
I mean, all we say is it's one test. There is no distinction to be made. The judge didn't make the distinction, and he didn't have to. He didn't. It would be misdirecting himself if he had said this is a very late application and therefore I must refuse. That would have been wrong. He didn't. He just said it's late. I'm looking at all the circumstances, and that is open to him to do. Then we get on to ground three, which I think is probably where the nub of this is. It's a fairly general opening to failing to take into account relevant factors and relying upon irrelevant factors, but essentially it is culpability. And OIC provide a list of the judge's only findings, as they call them. That OIC was wrong to wait a year and then issue a Dubai court claim. OIC was wrong to make reference to the JJC and to get the stay. That the actions might well have resulted in court time not being available to other litigants, and that OIC was wrong to wait until security for costs had been agreed before issuing that application. 1, 2, and 4 of those, as I've said in my skeleton argument, directly relate to OIC's culpable delay in their conduct. So looking at the first two first, about being wrong to wait a year and wrong to make a reference to the JJC.
Wrong to wait a year is conceded. Mr. Reid doesn't dispute that it should be put in the scales against him.
Yes.
And the JJC is all tied up with the Dubai court. So my proposition, I'll put this to you, if it was reasonable, if it was within the range of reasonable decisions to form the view that the court of the state in which the relevant company was incorporated was the appropriate place to go to obtain a binding determination with respect to the status of that company, and that decision was later found by the JJC to be wrong, it doesn't make it culpable. If the decision was reasonable but wrong, it doesn't mean that the conduct was culpable, does it?
No.
Well, I'm putting to you that it was, and that's why I asked you earlier about whether it was a reasonable decision to take to go to the place of incorporation to get a binding determination with respect to the status of the company. Because if that was reasonable, but it was turned out that the JJC formed the view that it was wrong because of the exclusive jurisdiction clause, then it's hard to characterise that conduct as culpable, isn't it?
Well, it's been very easy for the JJC to characterise it as culpable.
Yes, but what I'm putting to you, I think, is that the JJC was wrong in doing that. That's really what I'm putting to you.
Well, I don't think that is the case. When they had looked at the full arguments, they believed it was culpable. And they didn't just look at the case itself. They looked at the failure to challenge jurisdiction in the DIFC court. They looked at the failure to do anything else about it and to wait for so long in doing it.
Sorry, how could there be a challenge to jurisdiction in the DIFC court when there's an exclusive jurisdiction clause in the agreement?
Well, quite.
Well, so how can it be?
But if this had been what they're relying on is that this wasn't done legitimately. This was done purely to obtain a stay.
But what I'm putting to you is, what's the basis for that conclusion? There was a year's delay, I understand that, but leaving that to one side, why can you say that it was done for the purpose of obtaining a stay if it is a credible proposition of law that the place in which you launch proceedings for the determination with respect to the status of the company is the place in which that company was incorporated?
Because if they had done it for proper purpose, they would have done it immediately and gone to the DIFC court to seek a stay or some challenge to jurisdiction in order to stay those proceedings.
So it all comes back to the year's delay.
Well, that is indicative. That is indicative of what they were doing.
Right. Well, an inference of impropriety can be drawn from the year's delay.
Yes.
That's the proposition, is it? All right. I understand it.
And they have admitted they knew about it and declined to do anything about it for a year.
Yeah, but why did they? I know the reason they explained. Rupert explained the reason why they went to Dubai court, but couldn't they have challenged the jurisdiction in the IFC as well? Because they have accepted the IFC court as the tribunal to determine, or the forum to determine all the disputes.
Well, that's certainly what they. I don't think we can divorce the fact that there is an exclusive jurisdiction clause.
Hmm.
I mean, it may be that in other circumstances it would have been justiciable in another court, but that is not the circumstances. They had an exclusive jurisdiction clause, and they did not take any steps to promote this case for a year after it was brought against, notwithstanding two defences.
The contrary argument, which obviously failed in the JJC, but the contrary argument is that the exclusive jurisdiction clause confers exclusive jurisdiction on this court with respect to disputes arising under the contract. That is to say, with respect to the rights and obligations of the parties under the contract. An application to a court for a determination that a company doesn't exist is not a dispute with respect to the rights and obligations of parties under a contract. It's a determination which, if made by the court in the place in which that company is incorporated, binds the world. And it would mean that that company no longer existed and would have implications for the rights of a whole lot of other parties and would therefore be outside the exclusive jurisdiction clause. Now, clearly the JJC didn't accept that argument, but if it was a credible argument that could have been taken into account by the party at the time, I go back to the proposition that it is then difficult to characterise the conduct of the defendant as culpable, leaving to one side, and I understand your submission about the year's delay.
Well, That is to say that the JJC is wrong. And sorry, you're on mute.
I do that about 20 times every hearing. I apologise. I'm not necessarily saying the JJC was wrong. Really, what I'm putting to you is that there were finely balanced arguments. The JJC came down a particular way. And in that circumstance, leaving aside the year's delay, where there were finely balanced arguments, it's hard to characterise the conduct of a party who turned out to not win in the JJC as being culpable.
Well, I just find it very, very difficult to say that it is hard to do that. When, for example, the acting chairman of the JJT, the Chief Justice of the DIFC, the Secretary General of the Judicial Council, the Chief Justice of the Appeal Court, the Deputy Chief Justice of the DIFC, and the Chief Justice of the First Instance Courts, and Sir Richard Field, all found to the contrary. And if they can all do it, my lord, then could it possibly be said that this judge was wrong in agreeing with that, having seen nothing to the contrary as he saw it?
And do you, Mr. Knight, personally agree to the outcome of the JJC?
That is not for me to say. Oh, to the outcome of the JJC. I'm not going to
No
get
comment.
Huh?
Say that.
I'm not going to say anything. I'm not going to say anything.
Well, Mr. Knight, perhaps I think let's say the case started within the DFC, a common law expert lawyer handling it, and then they sought, let's say, consultation of another local law firms to deal with this matter, the nullity of a local established company. And we're sure that might take sometimes finding the proper law firm, discussing the matter, taking direction, what direction should they go, where to go, how to file, when to file. I'm sure that will take a couple of months as well. I mean, what do you think about this? Well, this is taking just Mr. Reed's defense that why they have approached a local law firm that decided to sue the local court.
My lord, one only has to look at the judgment. There was no explanation given. One can speculate that that happened. But we've looked at Mr. Kishore's evidence. He just doesn't give any. If he had said we had to go and find other lawyers, they took some time dealing with it, this happened, that happened, and that's why, nothing. Nothing. What he says is we recognized it right at the beginning. He even says that they raised it in the defense, but they didn't. But didn't develop it. Now that is not giving evidence which is going to persuade the judge when the burden is most definitely, as we've seen in the authorities, on the party asking to amend to give a good explanation for their delay. And they haven't.
Yes, you may go on.
But
yeah. How much time left for you? How much time you need, Mr. Knight, to finish up, to wrap up your submission?
And what's the time now? I will need, I think, another 20 minutes.
Okay, let's make them 13 minutes. How about that?
I'll see what I can do, depending on how many interruptions I get.
Let's see.
I promise to be quiet, Mr. Knight.
No, not at all. I need to know what I'm up against. What OIC has been saying is that it, or says in its skeleton indeed, is that it's consistently pursued the nullity case. Now, we say that that is not true and is indicative of the bad faith in this, but I rely more on the first, that one can't draw any other conclusion. These matters were explicitly in the original agreements. No one's under any doubt about them. As I've said, this is not a matter of issue which has been discovered in subsequent disclosure. OIC's admitted it was aware of the nullity issue when it filed its defence, but deliberately chose not to pursue it. It could have sought a stay. It could have gone off to the Dubai courts immediately. It could have sought a stay for those for that to take place. And the reason why the judge, it is not simply a matter of there being an 11-month delay. It is the claimant's conduct, OIC's conduct during that gives rise to other inferences. OIC's defence made an admission contrary to that. It was not simply a matter that they didn't deal with it at all. They admitted the contrary. They admitted the company was incorporated, etc. And then had to withdraw that later, as we've seen. It only began pursuing the nullity issue when it says it's consistently done it. It only began pursuing it on the 3rd of January. And again, without any notice. The judge was entitled, as he referred particularly to there being no notice in his summary of the facts. And he is entitled to take into account that this was simply sprung on us in imputing bad faith, just as the JJC had done. Now, even when we get to after the JJC decision, I'm going to come back to security costs in a moment. But sorry, I've lost my train of thought. No, I'm going to come back to those two in a moment. Next, I think we've been through at some length the discussion in the JJC judgment. As I say, it is an extremely strongly worded condemnation. What the judge was faced with was looking at that and then looking at the surrounding behaviour, looking at the lack of notice, looking at the prior delay, looking at all the circumstances, looking what had happened afterwards, the security for costs application, as we'll see, which he also dismissed, looking at the strength of the case, wondering why nothing had been done in that early period. And as he said, he saw nothing in Mr. Kishore's evidence to persuade him to the contrary. Now, OIC have just left the JJC with this judgment ringing in their ears. They apply for permission to re-amend, where it is clearly the law that they must give a good explanation for their delay. And we've seen all they could come up with. And in my submission, it was not unfair of the judge to look at what had been said about them before, to see their inability to give a proper explanation of the delay, both before the JJC and in going to the JJC. He was entirely unimpressed by that in all the circumstances. Not just looking at different elements in isolation. He saw a continuing pattern of delay and abuse. And he could take into account the strength of the case. It's worth adding that I don't think the members of this court will be surprised to find that there are suspicions that people abuse the stay. Indeed, I think 2 members of this tribunal were on the panel that ceased that automatic practice because of concerns over the opportunity, as I think you put it in your judgment, for such abuse. So they knew what they were going to be up against, or should have known what they were going to be up against, but entirely failed to persuade the judge who was going to be looking at it. And the burden was on them. It wasn't for us to show something else. They had to come along with a good excuse. And they failed, as the judge said, to come up with anything like sufficient explanation for their delay. They had the opportunity. It took them months to make that application. And they failed entirely to grapple with the issues. And he read into that an inability to be able to properly grapple with those issues. And it is not enough simply to say, we think the JJC were probably wrong. And it is really neither here nor there that he was a member of that tribunal. It's a highly distinguished panel who came to a unanimous view. Yes, sorry, for your note, it's paragraph 66 of the reasons, where the judge said, as already recorded, the JJC concluded that OIC had created a jurisdiction dispute solely for the purpose of avoiding or at least delaying resolution of GMGHS's claim, and nothing has been put before me that goes anywhere near to displacing that conclusion. And there we have it. There isn't anything placed before him. And I would hasten to add that it is not a ground of appeal that the judge was wrong. No, I accept. If he was wrong, he didn't take it into account. But that is not how the case has been put. We then get on to the security application. It may, in many circumstances, be reasonable to wait until you had security. But we're dealing with very specific circumstances here. The proceedings had already been going on for 2 years. Security for costs applications are supposed to be made before the first CMC. None had been made. They were content to go through the whole of disclosure without it. Only once they had been defeated in the JJC did they get round to asking for security for costs. And they then now say that they were justified in doing nothing with respect to amending, which on their own case was very simple and was all prepared. They do nothing about it for 4 months because they have decided to wait. But they are a party who has already delayed for 2 years in bringing this application. They have got to get on with things. It's not for them to simply say, without notice to anyone. There's no correspondence in which they said, we are going to wait to do this. Will you agree that we should not do this until you provided security? They didn't apply for a stay. There was no automatic stay, there was no stay in place. Now, my learned friend has taken you to correspondence about the security, and I said at the beginning that we offered much earlier. It was the 25th of November 2019. That we agreed in principle to provide security for costs. After that, it was simply a matter of negotiating the form. Now, if that application had been made timorously right at the beginning of proceedings, that may have been a justification. But by the time they've left it 2 years, all that other money has been spent on these proceedings. It really doesn't lie in their mouth to say we wanted to waste this trivial amount of costs on an amendment which we were already prepared to plead to await your security. The judge is perfectly entitled to find that that is unreasonable and culpable. And it's equally indicative of complete failure to communicate, just as the original application was done by surprise. Sorry, the buy claim was done without notice. To leave everything as late as possible and to be as uncooperative as possible. Not to raise issues when you should have done. That led the judge to the conclusion that this was not done bona fide and that it was culpable. Sorry, the provision of securities at page 2290. The agreement provides security on the 25th of November. So when my learned friend says that it's an eminently reasonable approach simply to wait for security without saying that's what you're doing, despite saying you're going to issue this imminently, despite now saying that it had already been argued, set out before, and that it wouldn't take much work to do. The costs had essentially all been incurred already. We say the judge was perfectly entitled to draw the conclusion that this was just spinning things out yet again to procure delay by means of a poor case. And one can't dissociate that from the other grounds. It is not simply a balance of prejudice test. Well, and the prejudice is much less because it's a poor case anyway. I know Justice Martin has promised not to perpetuate this argument. Those are my submissions on that point, that there was nothing wrong in the judge's decision.
Well, Mr. Knight, I mean, if you may allow me, is it your position remains that the only way to set aside the below judge decision and a conclusion that he arrived to is that in a case only he is so unreasonable?
Yes, though I accept that the test of reasonableness is a test of law. Having said that, it's not one that has been pleaded or made a ground of appeal. Things have been put in an extremely roundabout way, and we say there is things that he did take into account, and that having reviewed the evidence, he came to an entirely reasonable decision.
I'm sorry, Mr. Knight, I'm now in breach of my undertaking, but I thought you agreed with me earlier that if the judge was wrong to conclude that the delay from the period of commencement of the proceedings in Dubai was caused by culpable conduct on the part of the defendant, if that's not the proper characterisation of that conduct, then he has taken into account an irrelevant consideration. And if he's done that, then the discretion is miscarried, and then it would fall to this court to re-exercise the discretion. Did you? I thought you'd agreed with that.
Yes.
Yes. All right. And so that's a path.
What I'm saying is that that's not a path to success on the foot.
Yes. All right. But it is a path to success on the appeal that doesn't require us to find that the decision was so unreasonable that no person could have made it, isn't it?
Yes.
Yes. Thank you.
Yes. But you have to be able to find that. Yes. It then comes back down to the test for reasonableness of what they did. There's one final matter that's drawn into my learned friend Skeleton, the impact on other court users. It was clearly a factor in the judge's reasoning. All that is said by my learned friend in his Skeleton, I don't think he's pursued the matter orally, was that it does not on its own provide a reason for shutting out OIC. Well, it may not, but it wasn't the only reason. The judge was much more concerned about other reasons. So we say on that basis, ground 3 should also fail. There's only one other issue I'd raise. My learned friend says that this is a great matter of public interest and public policy in Dubai, and we've discussed the recent change in legislation. As I say, we believe we fall into the change, but this is, my learned friend is simply saying that this was part of the law for a time. It may not be the same as English law, but that doesn't give it any special status as the public interest that should be tried in some, should be reserved for trial. It was simply a piece of legislation at the time. It doesn't have any particular status that makes this case more important than any other, and that it should go off to trial. My lords, those are my submissions, unless I can help you any further.
Okay, thank you very much, Mr. Knight. Mr. Reid, you want to reply? How long will you take? Mr. Reid?
Rupert, I think you're on mute.
I'm not. I'm not.
Immortal words, you're on mute. I did just want to pick up a few quick fire points, if I may. The first is on what I'm going to call the pleading point in respect of the grounds of appeal. My learned friend took you to page 4 of the bundle, which is the grounds 1, 2, and 3, as set out in paragraphs 1.1, 1.2, and 1.3. It's obviously worthy of note that they are subparagraphs further to paragraph 1, the main body of paragraph 1, which says, in particular, having concluded the proposed re-amendment and counterclaim had a real prospect of success, the learned judge erred in nevertheless refusing to allow the proposed re-amendment and counterclaim. Now, obviously, erred is slightly antique English, but essentially what is being said is that the learned judge was wrong. I would accept the point that in this particular context, where one's dealing with an evaluation, wrong has a slightly higher threshold, and that threshold is unreasonable. And I take further Justice Wayne Martin's point as to the fact, obviously, that where something is, where the balancing exercise is where a matter is not taken into consideration, it ought to be, that is in itself a failure to take into consideration a factor. And again, that feeds into the analysis of the relevant assessment and balancing being wrong. My learned friend took the court to the Abdullah decision, which highlighted the respect to be given to a balance struck by a judge at first instance. And as I've argued at some length, what we say is that the balance simply wasn't struck. The balancing exercise was not carried out. I don't think I need to develop that submission. I've argued the point at some length. In terms of the JJC being binding, clearly it's binding on the question of jurisdiction. The problem comes when observations are made not as to the fact of a delay, but a suggestion or an allegation there is deliberate and culpable delay. And on our submission, there's simply no basis for the court, for the JJC to reach that finding. And it's certainly in our submission not binding on this court. And there's no suggestion, indeed, in Decree 1986.
Mr. Reid, there's one thing that's I want to make it clear to you. I know in the affidavit, somebody's affidavit, you did say that you filed the application in the Dubai court because you challenged the jurisdiction in the place where you registered the company. But you could have challenged that in the what do you call Dubai, the IFC as well, can't you?
Well, one could have, but we didn't challenge the. If we were wrong in the Dubai court, then the DIFC court would clearly have jurisdiction. So we couldn't say that the DIFC court had no jurisdiction. It's essentially a sequencing issue. Essentially, the view taken was that the nullity issue logically comes first. That needed to be decided in the Dubai court as the place of the courts of the place of the jurisdiction of registration. if we won in the Dubai courts, then yes, we would say that was the end of it. If we were wrong, then clearly there's a contractual issue to which we had the other defences, and that would then have needed to be determined in the DIFC court. So it wasn't that we were saying from the outset the DIFC court has no jurisdiction. That's why I suggested that actually, in a perfect world, what OIC may have done would be to, in terms of seeking the appropriate sequencing, to seek a stay in the DIFC court by reference to the assertion, which Mr. Knight seems to accept is reasonable, that that it ought to have been the Dubai court hearing the corporate issue, if I can call it that, and then if that was unsuccessful, then the DIFC court should hear the contractual issue. And indeed, that was the very nature of the submissions advanced by Globemed, their alternative submissions in the JJC, and we looked at those submissions to the JJC. Sorry, my lord.
Sorry, Mr. Reid. I think Mr. Knight expressly eschewed my invitation to him to accept that it was reasonable to go to Dubai to test the corporate status of the incorporated company, although he didn't offer any argument to the contrary. And my question for you, following up on the Chief Justice's question, is have you given us authority for the proposition that, leaving aside the exclusive jurisdiction clause, that the proper place in which to commence litigation with respect to the status of a corporation is the place in which the corporation was incorporated?
No, my lord, I haven't given you a chapter and verse in terms of a section in Dyson Morris. My understanding is that's a relatively trite proposition of conflicts of law as a general principle. And one can see the obvious logic in terms of the chaos that occurs if courts in other jurisdictions start to find that a company in one jurisdiction is a nullity, because clearly one has a conflict then between the fact of registration in the state of registration and the decisions of other courts. And as your lordship suggests, that there's an issue between the in rem consequences of a company being null and void and the in personam consequences that follow in the court of one jurisdiction. There's clearly going to be a significant risk of inconsistent judgments.
Well, that's my inclination too. But the parties haven't really joined issue on this in the submissions, either written or oral, and it seems to me to be quite an important point, because if there was a good jurisprudential basis for going to Dubai, absent the exclusive jurisdiction clause, then I think that is a significant factor in the evaluation of the culpability of the defendant's conduct. So I'm just wondering, it would assist me, I think, if we had some written submissions on that subject. Would either counsel have any objection to that?
Well, my lord, I'd have one caveat on that.
Yes.
And that, of course, is that they weren't before the judge, because those arguments were not made.
But I'm not sure that's, well.
Yeah,
they were not developed in any way like that. The judge was not persuaded by them. So,
my lord, it was all of the sequencing points and all of the suggestion that it was for the Dubai courts to decide the validity and the validity of the proper registration of a Dubai. That was certainly put before the judge.
All I'm asking for is legal submissions. I'm not asking for anything else, just the legal proposition. Yes. And should we do it simultaneously or sequentially?
My own preference would be simultaneously, just so that we don't have a lengthy debate. And
then so perhaps seven to 10 days each, and then simultaneous replies as well. That'd be convenient.
My lord, I wonder if we could say 14 days, only because I'm otherwise engaged next week.
Also true.
Yes. All right. 14 days for submissions and then 7 days for replies.
My lord, if that would assist your lordship.
Well, it would, certainly, I don't know about the other members of the court, but it would assist me. I think it is quite an important point.
I have no objection. I'll agree. I'll go along with you, Wade.
All right, thank you. Now, Mr. Reid, think I was I think I was the last one to interrupt you.
My Lord, I was just taking my quickfire points. On close of pleadings, if it assists your Lordship, it was suggested, I think, that pleadings closed in early 2018. The reality, of course, is that the amended particulars of claim were served on the 17th of May 2018, and that you have the court has those at page 268. There was then an amended defence, or there was an amended defence, which was the 1st of April 2018, and the court has that at page 339 of the bundle. I did just want also to deal with the chronology in terms of the stay before the JJC. So the JJC application was made on the 3rd of February 2019. That's page 386 of the bundle. And that, of course, is when the September trial date it has to be vacated. So that's our point about it being vacated 9 months in advance, and therefore there being no inconvenience to other court users and no waste of court time. The stay itself was ordered on the 7th of February, and your Lordships have that at page 400 of the bundle. The JJC decision was communicated on the 23rd of September, and that's when the stay was lifted. That's page 435. And then the application for security of the cost was made 28th of October 2019, and your court has that at B 1273. In terms of the stay of proceedings and the not entirely clear position as to whether when a security for costs application is made, the court proceedings should be stayed. There is provision in the RDC, and if I could quickly take the court to page 361 in the Blue Book, we have RDC 25.112, and I'll just read that out. Stay of proceedings. It's not usually convenient or appropriate to order an automatic stay of the proceedings pending the provision of the security. It leads to delay and may disrupt the preparation of the case for trial or other hearing. Experience has shown that it's usually better to give the claimant or other relevant party a reasonable time within which to provide the security, and the other party permission to apply to the court in the event of default. This enables the court to allow the claimant to choose if he wishes to provide the security, if he does, to dismiss the case. So the court, on the one hand, is saying there shouldn't be an automatic stay. On the other hand, it's saying that the party posting security should be given a reasonable time to do so. There's an implication there that they should be given there may be the need for some sort of non-automatic or discretionary stay. The position of the DFC court on this isn't clear. In the note that follows, we refer to the Veggie Bar and Emirates National Bank of Dubai properties case, in which the court gave the claimants 30 days in which to make a payment into court for security for costs and granted the defendant permission to apply to the court for the case to be stayed in the event of default of payment. So in that case, the court didn't make a discretionary stay, but gave permission to apply for a stay. So the position in respect of stays for an application for security for costs seems to be quite complicated and quite nuanced as a matter of DFC law. It's not clear, contrary to what I may have suggested earlier, that actually it's arguable that OIC should have applied or could have applied for a stay. And indeed, 25.112 is far from suggesting that it should have applied for a stay. And indeed, we maintain our submission that there can be no suggestion of any fault in not applying for a stay. Just by way of background, I want to very quickly take the court to page 448 of the bundle. And this is the email from Tamimi's of the 30th of October 2019. And at the bottom of 448, we see the reference to the proposed draft amended defence and counterclaim. So lastly, the defendant intends shortly to seek the claimant's consent to file and serve a re-amended defence and counterclaim. This will require some additional matters to be taken into account, and then 1, 2, 3, 4. And then at the bottom of that page, notwithstanding the above, the claimant is prepared, A, if the claimant is prepared to pay the requested security into court, and B, remedy its disclosure breaches, then the defendant would be in a position and prepared to consider a revised timetable on the basis that provision is made for the defence application for permission to amend. In any event, the defendant will provide the claimant with a draft re-amended defence and counterclaim as soon as possible. And then in the final paragraph, if the claimant does not agree to provide security and intends, in the absence of the defence agreement to its proposed amended case management order, to press the court for a reconvened CMC in order to set a new timetable, then the defendant will ask the court to list the CMC either after or at the same time as the defendant's application for security. There's no suggestion there of any intention to delay. it's quite clear that Tamimis and OIC are pressing for a prompt CMC and for prompt, if necessary, to allow the issue of security to be tied to that CMC, but in order that a trial timetable can be set. And that's what we really fail to understand, is if one looks at the underlying correspondence, it's quite clear that the application for security is genuine. One can well understand in circumstances where OIC believed that this case would be dismissed in the Dubai courts, that at that stage they didn't go to the DIFC courts to seek security. Once the JJC have decided that the corporate issues and the contractual issues are required to be determined in the DIFC courts, then one can well understand why an application would be made for security for costs in the, and I should say where there have been significant costs incurred on disclosure issues. One can well see why an application for security would be made at that point. Pausing there, the judge, one of the reasons the judge found against us was that he said the issue of security was plain from it was obvious from the outset that OIC would be entitled to security. Well, there's no suggestion in the correspondence that is the case. The initial refusal, which lasts until November or October to provide any security or to accept even in principle that we were entitled to security, we say is culpable delay on the part of Globemed and not of OIC. The principle could have been accepted much earlier. If it had been, then we could have proceeded much more quickly to trial. Finally, in respect of the fixed sentence judgment, and my learned friend took you to the postscriptum in that, the Chief Justice found that cases can proceed faster if decisions striking out and immediate judgment are where those decisions give finality are not made. That the court should be slow to strike out in circumstances where the matter is proceeding to trial. There is, with respect, a certain wisdom in that comment, because we are now in a situation where this is a case that is going to trial in any event, and if the judge below had not sought to remove from consideration the UAE nullity issue, then matters could have proceeded far more quickly to trial. So this is a case which proves the very point that was made in the postscriptum in fixed sentence. We need an order now that the amendment can proceed and that this case can now proceed to trial. I'm grateful for your lordship's time. Unless I can assist your lordships further.
Sorry, gentlemen, I've just got one question. That's the question of the perennial question of costs. It seems to me the costs issues consequent upon the outcome of this bill are quite complicated, because there's the cost of the original application for permission to amend, which arguably was an indulgence, and that's so therefore cost considerations might be different to that. Then there's the first application for permission to appeal, then the second application for permission to appeal, then the appeal itself. Are you happy if we just defer the whole question of costs until the appeal decision has been delivered?
My lord, yes. I mean, just very briefly, all of the appeal costs should be wrapped up. It seems to me, but I take your point about the court on an application to amend. It used to be the case when I started practice that you, as an amending party, you almost automatically paid the cost. We have moved on from that, and there's an issue about whether the application was properly made and properly resisted. But I accept that is a different issue from the issue in the appeal.
Right. So all the costs of the appeal cost should all be wrapped up. The application for permission to appeal should all go. But in terms of quantum, you have to leave that.
Save for any costs occasioned by the appeal, which we should have.
Yes. Yeah.
So, not by the appeal, occasioned by the amendment.
Yes.
So our amendment of any pleading we would have to do. We should,
of course.
But prior to this, I'm sure there were the courts of the registrars has already made necessary order for costs in respect of every application. No?
I think costs have been reserved. Costs are in the appeal. I think it's unlikely that Justice Lord Glennie would have decided to cost them.
Yes, cost in this appeal. Yes.
My lord, yes.
Yes, all right. And as to quantum, we'd leave that to registrar in default of agreement?
Yes, my lord.
Okay.
Yes.
Can we make it clear what was it that you are supposed to submit? 14 days from
Yes, please.
What was
yes.
the issue?
Well, I'm happy to clarify. It's my request. So it is submissions with respect to, if you like, the conflict of laws principles relating to the appropriate jurisdiction for litigation relating to the status of a company. And by which I mean leave aside the exclusive jurisdiction issue. It's just that is it ordinarily the ordinary conflict of law principle that an application for a declaration of nullity, or if you like, with respect to a corporation, should be made in the place of its incorporation,
Okay.
rather than somewhere else.
That's the question that you would pose. Okay, it's clearer
Yes.
now because
Does your lordship want to set a page limit just to
Yes. How long do you? How much do you want? 5 pages?
5 to
Not
10?
too
I would have
long.
thought is a.
10. 10. All right. 10.
Five should be
more than
plenty.
10.
It should. I mean, I'm hoping there's a paragraph in Dicey and Morris that will tell us the answer.
Yeah. Okay.
Yes. 10 page
So
limit.
to the council,
I think
thank you very much.
we would urge a 5. We would say. In fact, my learned
Right.
junior thinks he may even have the paragraph number, but if we could say 5 just to.
5.
Yes.
5
Yes.
tonight?
Not more
Yes.
than 5. Not more than 5, please.
I'm great.
But
And,
14 days for submissions, 7 days for submissions in response.
Yes.
Yeah.
So
Good.
to the council, thank you very much for your your submission was great, very good, easy to us to understand, or at least for me to understand. So
Great.
thank you very much. It's very helpful for us in making decisions.
And
The
thank you to
council
all of the
will-
court for sitting at various times of day, wherever they may be, or night.
I'm 7:30 p.m. now. 7:30 p.m. Just with Justice Dwayne is also 7:30 in Perth. His time and my time are the same. So so thank you very much indeed. We will reserve, of course. We got to receive your submission first, and then we'll decide how it's going to go.
So, Chief Justice, should we go back to
what-
that link we were using earlier?
Yes. I come back.
All right.
So
Yes,
thank you
all
very
right.
much.
Thank you.
Thank you.
Mr.
Right.
Rupert Reed and Edward Knight. Thank you very much, and all you.
Thank you.
Thank you.
Goodbye.
And thank you to all the back team, back room